सीरियल नंबर 1 फौजदारी अपील नंबर 122 विद्वान वकील श्री एसबी कादरी महावीर भाई बाबू भाई हाजी रेकॉर्ड आई क्या रखो हियरिंग 13 फौजदारी अपील नंबर 6822 पीपीसी जोशी विद्वान वकील श्री बीएम कल्याण 323-498 सरकार दाखल हाजी रेकॉर्ड आई जी फौजदारी अपील नंबर 823 पीपीसी जोशी कालिदास अमरसिंह भाई नोटिस કરી બજી ગઈ છે સમાન નોટિસ બજી ગઈ છે ફौजदारी अपील नंबर 923 पीपीसी जोशी એ છે સર કાલિદાસ અમરસિંહ ભાઈ એને જ આરોપી છે અમારી નોટિસ બજી ગઈ છે सीरियल नंबर 8 सेशंस केस नंबर 97-19 विद्वान वकील श्री एसबी कादरी विद्वान वकील श्री वीएन अजवालिया जयेश भाई मूलचंद भाई 4 आरोपी
एमआर जोशी क्या है આવે છે
बेसा
जी सर
આવ્યા છે જયેશભાઈ મૂલચંદભાઈ કિશનભાઈ અશોકભાઈ મોહિતભાઈ મનોજભાઈ પ્રશાંતભાઈ રસિકભાઈ આરોપી નંબર 4 से अंजवाड़िया यस चार के सेशंस केस नंबर 38-22 विद्वान वकील श्री एस वाई हमीराणी वकील श्री एनएस मेहता विद्वान वकील श्री एम आई डेरिया मोहम्मद जुबैर जाहिद भाई आरोपी नंबर 1 से वकील ने करो क्या अनिश समय है वो पहचान करने की कोशिश 6 आरोपी मोहम्मद जुबैर जाहिद भाई अमीन भाई नुस भाई નથી मीत भाई बकुल भाई अजहर भाई हनीफ भाई
મારા બંને આરોપી છે
शाहरुख भाई मोहम्मद भाई जुनेद भाई फारूक भाई फरियादी ने बोलाया है फरियादी परेश भाई श्याम भाई
લેવાના છે હા છે ડેટ લેવાના છે ફરિયાદી એવું કાઉન્ટ કમ્પ્લેન્ટ હા સર સમાધાન થઈ ગયું છે પણ છતાં
પણ એ એપ્લિકેશન આપો બેસાડો
હા હા અને સર નંબર 1 કોપી છે હું વીપી મૂકું
બેસો બા सीरियल नंबर 10 सेशंस केस नंबर 74-22 વિદ્વાન વકીલ શ્રી આઈપી ચૌહાણ, વિદ્વાન વકીલ શ્રી વીએન અજવાળિયા, વિદ્વાન વકીલ શ્રી ડીએસ ભાયાણી, વિદ્વાન વકીલ શ્રી આચાર પરમાર, વિક્રમભાઈ કલ્યાણભાઈ, અગિયાર આરોપી છે ટોટલ 14 છે. ચાર ત્રણ સામે એક્સપોર્ટિંગ અલગ કરવાનો હુકમ કર્યો છે. ઓકે. આરોપી નંબર 5, 10 અને 12 એની સામે અલગ ટ્રાયલનો ઓર્ડર કર્યો છે. વિક્રમભાઈ કલ્યાણભાઈ, દેવેન્દ્રભાઈ પ્રાણશંકરભાઈ, પરસોત્તમભાઈ ભવાનભાઈ, હીરાભાઈ જાદવભાઈ 5 નંબરના આરોપી છે એક્સપોર્ટ છે. કાનાભાઈ મંગાભાઈ, એ રીતે જ છે. રમેશભાઈ નાથાભાઈ, મોહનભાઈ ગોવિંદભાઈ, છગનભાઈ હરિભાઈ, બાબુભાઈ ખોલાભાઈ અને 14 નંબરના આરોપી સાહેબ હાજર નથી એટલે એક્ઝામ્પશન રિપોર્ટ છે.
ડી લિસ્ટ
આવી ગયું છે.
બને ડી લિસ્ટ આવી ગયું છે. હવે કોને બોલાવવાના બાકી?
હા બાકી છે.
આજે રજૂ કર્યું છે કોને? વિટનેસીસ 1997 નું છે શું કમિટ અમુક થયું છે જોઈ લેજો. આ વિટનેસ ને બોલાવવાના છે કઈ દેજો નેક્સ્ટ ટાઈમ આવતી તો વિટનેસ આવશે. લિસ્ટ ઓફ ડોક્યુમેન્ટ આજે પ્રોડ્યુસ કરી દેજો. ચાર ત્રણ
કોને બોલાવવાના છે પછી
આપી
સેશન કેસ નંબર 9322 વિદ્વાન વકીલ શ્રી કેબી શુક્લા, શિવાભાઈ અલિંગભાઈ, શિવાભાઈ અલિંગભાઈ, મહત્વભાઈ બાબલુભાઈ, નંબર 2 નથી. હરદીપભાઈ ધીરુભાઈ, ભરતભાઈ ધીરુભાઈ, રામકુભાઈ બાલાભાઈ, કુલદીપભાઈ જેલુભાઈ, બાબુભાઈ દોલુભાઈ.
પંચ આવેલા છે. હા સાહેબ 2 પંચ 4 અને 5 આવેલા છે. હા સારું પંચ ને લઈ લઈએ 2. જી સર બોલાવી લો.
નથી આવ્યો એક્ઝામ્પશન
આપી દો 2 અને 4 ને ફટાફટ બોલાવી લેજો. હાજી હાજી બોલાવી ઉપર એમ આઈ દે રહ્યા
સ્પેશિયલ જેબી 2222 વિદ્વાન વકીલ શ્રી એમ આઈ ડેરિયા, લાભુબેન તલસીભાઈ.
બોલો બોલો.
આરોપણ બેન છે ને સાહેબ એમને સાહેબ મેં રજીસ્ટર રેડી થી સાહેબ જાણ કરી દીધી સાહેબ હું વકીલ તરીકે છૂટો લાસ્ટ ટાઈમ મેં આમ અરજી આપી હતી પણ નામદાર સાહેબ એમની એક્નોલેજમેન્ટ સ્લીપ અને
યુ આર રિટાયરિંગ ફ્રોમ
હાજર એમના દીકરાને વારંવાર હું ફોન કરું છું
અવેલેબલ વોરંટ ઇશ્યુ કરતે
બને
એમની ઈડી છે અવેલેબલ વોરંટ ઇશ્યુ.
2 કેસ છે સાહેબ, સિરિયલ નંબર 12 અને 13 બંને છે.
અવેલેબલ વોરંટ આજ કામ કરતે ધેન ફરિયાદી બેમાં છે એમ આઈ દે રહ્યા.
સ્પેશિયલ જેબી 6122 કાળુભાઈ ભૂથાભાઈ,
57 એમાં આયા છે કમ્પ્લેનન્ટ આવેલા છે.
માં જે ડેપ્યુટી એન્જિનિયર આવ્યા છે પંચાલ
નથી કોઈ
નેક્સ્ટ ડે રાખી દો.
એમને કેસ પાસે એમને કોઈ એવું કીધું કે જીબી માં
It is your problem. You have to deal with it. Whether you તમે સિંગ કર દો. તમે બે ત્રણ નવો વકીલ રોકી લો ભાઈ. 2 માર્ચ 2:75 છે. પેલામાં હાઈકોર્ટ ટાઈમ લિમિટ માં આવી ગયા છે એડવોકેટ્સ. મેટર હાઈકોર્ટ ટાઈમ લિમિટ છે એમાં આવી ગયા છે. So within 15 minutes, I will adjust my board and 1 or small 2 witnesses are there. I will, within 15-20 minutes, we will start.
મહેશભાઈ મગનભાઈ,
આરોપી પકડ. શુક્લા.
શિવાભાઈ અલિંગભાઈ.
માર્ક 5/5.
5/5 અને 5/6 ના પંચો છે.
હા.
6 નંબર કીર્તિભાઈ કબૂલ કરવા
એક
જેવું છે.
પંચ જ આવે. બંનેમાં એક પંચ આવે. શું થયું? બેસી જાઓ.
મહેશભાઈ મગનભાઈ.
Okay. No, it is up to you to whether you want to admit the panchnama or not.
મહેશભાઈ આવી જાઓ.
26 એક્ઝિબિટ 26 વિટનેસ નંબર
March.
દિવસ પછી રાખો થોડું ઇન્ફેક્શન છે, થ્રોટ ઇન્ફેક્શન.
So
હજી આ 10 દિવસ સાહેબ થ્રોટ ઇન્ફેક્શન રહે.
હે?
ઓછા 10 દિવસ આ બધું ડોક્ટર ગુરજીત સિંહ ને દેખાડો મને અત્યારના વાયરલ ઇન્ફેક્શન છે આ બધા. 11મી રાખો સર 11મી.
11th નહીં, 11th તો holiday. 6th, 7th,
છઠ્ઠી રાખો.
6 March. પેલામાં કઈ એસવા હમીરાણી એમાં ઓકે તેને પુકાર કરીને તારીખ આપી તેને કમ્પ્લેન એક્યુઝ ને કોલ આઉટ કરીને ડેટ આપી કમ્પ્લેનન્ટ ઇઝ seeking time.
હા મેં જોયું છે, હું સીન કરી દીધો રિપોર્ટ.
ઓકે.
એસવાય હમીરાણી.
આરોપી પુકાર
મોહમ્મદ જુબેર જાહિદભાઈ.
ફરિયાદી હા ફરિયાદી શું છે? ફરિયાદી બોલે.
હાજી ફરિયાદી પરેશભાઈ શ્યામભાઈ.
સ્ટાર્ટ ફ્રોમ 4th March. ચોથી તારીખ ભી કમ્પ્લેનન્ટ ક્યાં ગયા?
હું કહી દઉં છે બેન.
4th March. ઉભા છે
હા કહી દઉં. જી સર.
પૂછવાનું સીરિયલ નંબર 8. હા એમાં મિસ્ટર એમ આર જોશી
97
પેલી
19
કાદરી વીએન અજવાળિયા એમાં યુ સ્ટેટેડ કે the victim is a minor, but whether any documentary evidence has been produced that he is a minor, either he is a living school living certificate or a birth certificate like that.
હું છે બપોર એક્સપ્લેન કરું. હું બપોર જોઈન કરી દઉં.
એક આરોપી પુકાર કરીને 3-4 દિવસનો ટાઈમ આપો.
હા વાંધો નહીં, હું બપોર જોઈ લઉં. મેં સાહેબ એની ડિપોઝિશન ઉપર
Position is a different thing. Even in
They-
the case of a POCSO, even if the victim is a minor, you must.
આઈ એગ્રી, પણ એમાં છે જે સવાલ જવાબના સ્વરૂપમાં એની ડિપોઝિશન છે સાહેબ.
It's a different thing. We are not saying whether it's a evidence has been recorded.
એટલે એના ઉપર મારી આર્ગ્યુમેન્ટ સાહેબ.
First of all, the question is whether he is a minor or not, that the victim is a.
એટલે એના ઉપર મારી સાહેબ આર્ગ્યુમેન્ટ ત્યારે આવી હતી, પણ છતાં મારી પાસે સાહેબ દાખલો હોય તો હું સાહેબ જોઈ લઉં.
વીએન વિદ્વાન વકીલ છે વીએન અજવાળિયા. એમાં તમારા અસીલ નથી હો, પ્રશાંતભાઈ રસિકભાઈ હાજર
આવી
નથી. આવી ગયા.
Yes, call upon all the accused.
જયેશભાઈ મૂલચંદભાઈ.
આવી ગયા 21, 22,
હાલશે
21,
જી સર
21
જી મત ઓબ્લાઈશ
7 એ call out કરવો હોય. સિવિલ જે છે ને પછી કોમર્શિયલ અપીલ
કોમર્શિયલ અપીલ નંબર 123 વિદ્વાન વકીલ શ્રી આરજે શુક્લા, વિદ્વાન વકીલ શ્રી ઈશી પંડ્યા, વિદ્વાન વકીલ શ્રી કેસી દેસાઈ.
એપલ દલીલ કરે ત્યાં ઉમેશભાઈ નીકળી જશે આવી જશે ત્યાં સુધી સ્ટાર્ટ.
Your Honor has the appeal papers as well as the paper book which was filed by us in the High Court.
original record is there also, and the paper book you have submitted before the High Court is also.
Very well. So I'll refer to the documents from the paper book
Okay.
for convenience because
Page number is given there.
page number is given there. And we have also prepared a separate compilation which I'll just tender. But before that, so broadly I'll indicate what the matter is about. There are 4 parties involved.
Yes.
One is the plaintiff who is the purchaser of a vessel.
I think only one is not been served but not appeared, I think.
Yes, because Capital Corp, they have not appeared in the suit.
Already passed an order to proceed ex parte because he's already been served but nobody appeared.
Nobody appears. And that has been the case all throughout. Even before the trial court, before the High Court, they have not appeared. So I was indicating, if your lordship sees the plaintiffs are purchasers of a vessel which was of the ownership of defendant number 1, who is no longer appearing before the honorable court. Number 2 are the plaintiff's bankers. And number 3, DBS Bank is the appellant before your honor.
Yes.
Now, under an agreement, my lord, the plaintiff agreed to purchase one vessel. The terms I'll show, my lord. I'll just broadly, first of all, give an overview of the matter and take your honor then to the documents. So there was an agreement for purchase of a vessel under which the plaintiff was obliged to open a letter of credit. Canara Bank is plaintiff's bankers. They opened a letter of credit where the beneficiary is the defendant number 1 and the notified bank is defendant number 3, DBS. That letter of credit also permitted negotiation. So the beneficiary could have presented the documents to my client, that is the Singapore DBS Bank, for the purpose of negotiation, and an early payment could have been obtained that was permissible under the letter of credit as well as the agreement, and that is what eventually happened. So those documents were presented to us, DBS Bank, by the beneficiary, that is the defendant number 1. Those documents were forwarded by us to Canara Bank, that is the defendant number 2. Canara Bank shared those documents with the plaintiff, and eventually plaintiff confirmed. I will show that document which has come from the record of DBS Bank, Canara Bank, and Canara Bank also gave us the green signal, in pursuance of which we paid the money to the beneficiary, which we are entitled to receive from Canara Bank after the credit period gets over. Now, during that period, after we paid the money to the beneficiary, that is the defendant number 1, and before we could demand that money from Canara Bank, because the credit period was still on, some disputes obviously arose, and the vessel which was sold by the defendant number 1 to the plaintiff was not delivered. Plaintiff therefore filed a suit saying that the encashment of the negotiation and payment under the letter of credit has wrongly been done, and therefore I am not obliged to pay this money.
He did the fraud.
Not actually, because I'll show to your honor, there is no fraud which is pleaded a fraud, of course, against defendant number 1. But as far as the bank guarantee is concerned, no fraud was pleaded. That is the distinction which I will draw, because the law is that a fraud which is played by the defendant number 1 is not relevant for the purposes of the bank guarantee and the letter of credit law. The underlying fraud has to be in context of the letter of credit or a bank guarantee, as the case may be. So as far as that is concerned, there was no fraud pleaded. Their entire case is, sir, that on their interpretation and reading of the documents, they believe that unless a notice of readiness was given and the documents to be produced included a notice of readiness, the negotiation of the letter of credit could not have happened, could not have taken place. So according to them, since that document was not produced, their case, which was pleaded before the trial court, was that I wrongly negotiated the letter of credit and paid money to the beneficiary. And because I did not take adequate care in examining the documents, I am not entitled to receive that money. That is their case, which the trial court has accepted. Ignoring the fact, and because I'll make it good if when we go to the trial court judgment, ignoring the fact that as per the practice, because these letters of credit are regulated by UCP 600, which is the applicable UCP, and it is mentioned in the letter of credit itself. So there is a reasonable care and caution which is to be exercised by the banks. At the same time, my obligation is to collect documents, forward it to Canara Bank. Canara Bank in turn will obtain the approval from the letter of credit issuer. So here in this case, the plaintiff. And only upon verification will I get the green signal to pay. And that is what has happened. Now, the trial court has completely ignored this aspect of the matter. And in my respectful submission, completely ignored, or rather not properly dealt with UCP and the Supreme Court judgment in Federal Bank. So this is how the matter stands. It is, in my respectful submission, the issue is very limited. I will have to show to your honor the letters of credit, the agreements between the parties. And for that, sir, I have prepared, if your lordships permit, a separate compilation so that we don't have to go through the entire bulk of documents. These are my documents. Can you keep them? So, sir, this compilation of documents contains the agreement, first of all. Below the very first document, have you shared it? The very first document is the agreement. Now, there are two parties named here. This memorandum dated 21st April 2021 between Capital Corp. Capital Corp is the defendant number 1, who is described as a seller in the agreement, and Hussain Ispat, which is the plaintiff. Now, the relevant terms, clause 1 at the bottom of the page, purchase price, payment may be seen. Buyer to establish a confirmed irrevocable letter of credit from Punjab National Bank. Subsequently, it is changed to Canara Bank. Initially, it was Punjab National Bank. For US dollars, so and so. So payment was to be by way of letter of credit. Now, what is important is on the next page, clause Roman 2. Yes. Opening bank to provide necessary instruction to confirming bank to permit discounting of letter of credit upon receipt of appropriate documents from sellers. So it was already agreed between the parties that irrespective of the delivery, etc., it would be open for the beneficiary, the vendor of the vessel, to discount the letter of credit upon presentation of certain documents. Now, the documents to be presented are also listed here, presentation of documents. A to F are the documents over which there is no controversy. G may kindly be seen. Attested telex or swift advice from the opening bank confirming that the buyers have received the notice of readiness that the seller or seller's agent at Alang that a vessel has been physically delivered to the buyers. So when the agreement was entered into, the plaintiff wanted that payment should be made only once the vessel is physically delivered, and therefore the agreement also provided, the last words are important, that the vessel has been physically delivered to the buyers. Now, I am emphasizing this and I'll show that subsequently it has been changed from physical delivery to notice of readiness. That your honor will see a little later. Then on the next page, account name, etc. Now please see below clause 6. The expected time of delivery was 25th May 2021 and the date of cancellation was 5th of June 2021 on page 3, clause 6. Now this gets delayed to October. Eventually the vessel is not delivered. I am showing therefore originally when in April they executed this agreement, the idea was that we will get the vessel by 25th May 2021 and only after the physical delivery of the vessel the payment will be remitted. That was what the parties had understood, and when I say parties, I was nowhere in the picture then. I am the negotiating bank and the notified bank. Then your honor will find at page 6, there is a clause regarding notice of readiness. The seller shall issue the notice of readiness for delivery only after the vessel has arrived at a safe anchorage along and is ready for effective physically deliver. So physical delivery of the vessel within the Indian territorial waters was absolutely a requirement in the agreement as it was originally executed. Now, I am emphasizing this because when your honor sees the trial court judgment, your honor will find that the one blame which has been put upon us is, as DBS Bank, is that we did not verify that the vessel is physically delivered or not. Now, what was a requirement earlier was done away with. The only requirement which subsequently remained and which was also in the form of additional documents was that there has to be a notice of readiness. So this physical delivery part has subsequently been done away with. That is what I want to emphasize. Then, sir, your honor may see page 8. This is the first amendment, not relevant for our purposes, but just for the record. The original agreement undergoes an amendment. First of all, on 23rd April 2021, basically the amount has been enhanced. Then at page 9, in terms of the agreement, this is the letter of credit as it was originally opened. This is the original letter of credit. It was opened on 26/4/2021. Because that date, your honor will find 6th item of the table. Then 2 items thereafter, sender bank is Canara Bank, receiver bank is DBS Bank, which is my client. Canara Bank is defendant number 2. Then field 40A, form of documentary evidence, which is irrevocable letter of credit. Then 2 fields thereafter, field 40E, applicable rules, your honor may kindly note, 40E. UCP latest version. So this bank letter of credit and all letters of credit are basically regulated by this UCP latest version. Then field 50, the name of the applicant is mentioned, Hussain Ispat plaintiff, beneficiary is Capital Corp. Then we can, sir, straight away go to page number 11. Now, before that, your honor may see top of page 10. It actually is part of field 41A starting at page 9. It is available with, it says DBS Bank, etc. and over the page by negotiation, your honor will find. 41A gives the details. So it is available with the DBS Bank by negotiation and then drafts at 150 days from the date of physical delivery of the vessel. So this is the credit period which is available, 150 days. We are not really concerned with all this. I'm just indicating. Then your honor will find what we are concerned with is at page 11. Now field 46A provides the required documents. Yes. Sir, first 6, these are in terms of the agreement. I have shown the required documents in the agreement. Please see 7th item at page 11, because that is the subject matter of controversy. The first 6 are not. 7th item says, attested telex or swift advice from opening bank confirming that the buyers have received the notice of readiness from the seller or seller's agent at Alam that the vessel has been physically delivered to the buyers. So this was in conformity with the agreement. which talked about physical delivery. So even while opening the letter of credit, the documents required, sir, this is very crucial. Field 46A talks about the documents required. So documents required for the purpose of obtaining the payment under the letter of credit spoke about as item number 7, a tested telex or swift advice from opening bank, confirming that buyers have received the notice of readiness that the vessel has been physically delivered. So it was a requirement of the letter of credit that some document showing that the vessel has been physically delivered had to be there in the documents to be presented for the purpose of payment. So even when the beneficiary, in this case Capital Corp, the defendant number 1, wanted to negotiate, then he had to provide these 7 documents. Provide these 7 documents to us. We will then forward these documents to Canara Bank. Canara Bank would show the documents in turn to the plaintiff, whereupon, if we get the go-ahead, we will release the payment to the Capital Corp. So these were the 7 documents. Now the next field is provides for additional conditions. Your Honor may kindly note the difference in the language. 46A talks about documents required, whereas 47A talks about additional conditions. So as a condition of this letter of credit at page 12, item number 8 may kindly be seen. The seller shall issue the notice of readiness for delivery only after the vessel has arrived at a safe anchorage along India and is ready for effecting physical delivery. So this again is in conformity with clause 16 of the agreement at page 6. So clause 16 of the agreement between the plaintiff and the defendant number 1, which spoke about NOR, is included in additional conditions, whereas the documents required, which included this certificate or swift message saying that the vessel is delivered, is included in the documents required column. It assumes a little significance because eventually, as we see, in the additional documents column, there is a mention of a notice of readiness, but it is not a required document. So when I am dealing with the documents, I must only focus on the documents which are required for the purpose of payment under the letter of credit for the purpose of negotiation. And so would Canara Bank be. So therefore, I am trying to emphasize that these are 2 different columns, one which was providing for documents required and the second additional conditions. Then, sir, on that page 12 itself, field 78, this is the procedure to be followed. Upon negotiation, Your Honor has that?
Yes.
Upon negotiation, the documents should be forwarded to us in one lot to our address, Canara Bank, Bhavnagar, branch 20 so and so. Upon receipt of documents at our counter on due presentation on or before 5/6/2021, drawn in compliance with the credit terms, we shall remit the funds on due date as per negotiating bank's instructions. The negotiating bank should mark all the negotiations on the reverse of this letter of credit. Now, sir, this is very important because irrespective of what is mentioned in UCP, etc., and this is in conformity with UCP, I'll show. But what was agreed between me and Canara Bank as per this letter of credit is, because this is a letter of credit which is opened by the Canara Bank, where I am the notified bank. I am the bank notified for the purpose of this letter of credit. So I am told by Canara Bank that upon negotiation, the document should be forwarded to us in one lot. That is one. And second says, upon receipt of documents at our counter on due presentation, on or before 5/6, drawn in compliance with the credit terms, we shall remit the funds on due date as per negotiating bank's instructions. So because under the relevant UCP, it becomes the obligation of Canara Bank to verify the documents which I present for the purpose of negotiation. Once they approve of the documents, they will tell me that we approve of the documents, you remit the funds. And that is what is contemplated by the letter of credit. That is what is contemplated by the UCP, and that is actually what has happened as far as this present transaction is concerned. Then Your Honor will find this is the letter of credit as it was originally opened. Then please see page 14. Now, the defendant bank receives a request from the plaintiff on 4th May 2021. But 25th May 2021 was the date of expected time of delivery. But on 4th May, Hussain Ispat, the plaintiff, writes to Canara Bank saying, we want to request you to amend LC as stated below. So they sought amendment of the LC, and clause 2, which says field 46A clause 7, attested telex or swift advice from the opening bank confirming that the buyers have received the notice of readiness from seller or seller's agent in Alang that vessel is ready to be delivered physically to buyers. Ready to be delivered physically, not actually delivered. Your Honor, if we can compare the language of the substituted clause 7 with the language at page 11 of the clause 7 of the original LC. Originally, the LC says that the vessel has been physically delivered. That has been now changed. Vessel is ready to be delivered physically to the buyers. So the requirement that the vessel should be in Indian territorial waters, physically delivered to the plaintiff, whereupon only the payment should be remitted, is done away with. Now it talks about a notice of readiness to be given. So this is 46A clause 7. So in the documents required column, 46A documents required. Then, sir, in terms of the request made at page 15, the letter of credit has been amended. And Your Honor will find at page 16, 46 field 46B, documents required. In that, the second point number 7. So it says at the top, field 46A. Then it says point number 4, now to be read as, that we can ignore. Then thereafter it says point number 7, now to be read as. And it says, last two lines, vessel is ready to be delivered physically to the buyers. So actual delivery part is done away with by amending the LC. Then Your Honor will find at page 17, there is another request for amendment with which we are not concerned. It is basically the amount which they wanted to be changed. So 17 we can skip. 18 is also another amendment to the memorandum of agreement, not relevant for our purposes. Then Your Honor may straight away go to page 20. Another request comes, 15th May 2021. Your Honor, only just keep in mind the date of delivery, which was 21st May. So a week before that, this request comes. We, Hussain Ispat, having MOA so-and-so, dated 21st April of total value of so-and-so, of which open dated so-and-so. Now the seller, who is Capital Corp Asia Private Limited, wants LC of full amount from Canara Bank, Bhavnagar, as per addendum 2, dated 15th May 2021. Please do the needful and oblige. So the amount of LC now becomes the full consideration amount. And this is on 15th May 2021. Then on the next page, page 21, now this is a communication issued by the defendant number 1, the seller of the vessel, to Hussain Ispat, the plaintiff. This is very important, Manoj. LC to be amended as under. In field 46B, point number 7 to be deleted. So 46B, point number 7, originally said, if Your Honor sees page 11, point 7, physical delivery. I'm not reading again, but just to correlate things. This was subsequently changed to a notice of readiness. So from the documents required column at page 11, point 7 has now, there is a request to delete it completely. So just Your Honor may see only 3 documents. Page 11, bottom 7, which is subsequently amended at page 16, clause 2, page 16, field 46B, second part, where they now talk about notice of readiness, and that also has been deleted from the required documents column, 46A.
This was a request by the.
Yes, it has been done subsequently. It has been done. It has been done. So there was a request from Capital Corp to Hussain Ispat that please delete clause 7, and then please see in the next paragraph, in additional condition 47A, following to be added. So from 46B, which was the field for required documents, this notice of readiness part has been shifted to the other conditions. A document to be presented after the receipt of an authenticated SWIFT message as under attested telex or SWIFT advice from the opening bank confirming that the buyers have received the notice of readiness from the seller or seller's agent at Alang that the vessel is ready to be delivered physically to the buyers. So, sir, what was the amended condition number 7 in field number 46A has been deleted from 46A and has now been added to 47A, which is additional conditions and not documents. Your Honor may kindly keep this in mind, because my entire case revolves around this. That what was originally a required document becomes an additional condition by virtue of this amendments. Now there is an amendment in terms of this. But page 22, first of all, just to complete the chain of events, the expected time of delivery from 21st May was changed to 15th of June 2021. This happens on 21st of May 2021. So these documents I have sequentially arranged date-wise. So I am therefore just for the continuity sake. Then, sir, page 23 is where they incorporate the change which Capital Corp wanted Hussain Ispat to have in the amendment. LC, page 23. Please see field 46B at the bottom of the page. 46B. Documents required. Yes. Field 46A, delete point number 7. Your Honor has noted that. So just above that handwritten part, 46B, yes, document required, and against that,
Deleted point number
delete
7.
point number 7 of 46A. So page 11, point number 7, as modified by page 16, gets deleted. And then 47B, add point number 9. Document to be presented after receipt of an authenticated SWIFT message as under attested telex or SWIFT advice from the opening bank confirming that the buyers have received the notice of readiness from the seller or seller's agent at Alang that the vessel is ready to be delivered physically to buyers. So what was originally part of documents required now becomes part of additional conditions. Now, their entire case is based on this. That when I presented the documents to Canara Bank, when Capital Corp presented the documents to me and I presented to Canara Bank, it did not include a SWIFT message in terms of 47A, condition number 9. This is their entire case. Now, whether non-inclusion of this SWIFT message, which is not a document required, it is just an additional condition, whether it will vitiate the entire negotiation of the LC by me, because before I actually pay the money, I received the documents, the 6, now in the documents required field, now there are only 6 documents remaining. 7th has been shifted to additional conditions. So the 6 documents which are required by the documents required field, read with their agreement, were received by me from Capital Corp and forwarded to them. I'll show that. Now, if I have done that and after receiving the go-ahead from Canara Bank, if I have paid money to Capital Corp, can I be faulted? That is the short issue for your Honor's consideration. Then, sir, on the next page, on 28th May 2021, now this is the communication which I am talking about. I receive a request. Sir, earlier, even if Capital Corp wanted to negotiate the LC, they could not have done it because the required documents field said that there has to be a message saying that the vessel has physically arrived. So they could not have done it. They wanted to negotiate the LC. They wanted the money. So they requested Hussain Ispat that if you continue with this requirement in the documents required column, we will not be able to negotiate the LC and we will not get the money. And it seems, because we are not concerned with all that, but it seems that the vessel was entangled in some litigation or whatever. So for some reason, Capital Corp was not in a position to move the vessel to India, but it wanted the money. So they requested Hussain Ispat that, sir, instead of this documents required, you shift it to additional requirements, such that we can present the 6 documents which are there in the documents required column and negotiate the LC. Then you will, obviously the vessel will come and you will get your money. That was an assurance. Obviously we can read between the lines, but that must have happened. So immediately after this amendment of the LC, shifting item number 7 to the additional, they made a request for negotiation. So at page 24, we write to Canara Bank, please see our bona fides, sir. Today, the entire attempt seems to be to somehow fasten this entire liability upon DBS Bank and to get out of this.
So do you know where this document is on record?
Yes, it's part of the record. It's part of the record.
Do you know the page?
I will show you. It is page number 172. The original record page is mentioned here. Amrita, 172. Paper book 172.
Paper book. I think I have 172.
Just check. If it is not there, then this was shown by me to the trial court also. Sir, page 172, which is mentioned on this page number 24, is part of that paper book record, and I believe that, and it can be verified from the original record also.
I don't know.
No, it's okay. Anyway, you verify. If it is not there, then we can. This, I believe, has come from the original record, 172.
172, yes.
It's the same document.
28 May 2021.
That's right. 28th May 2021. Now, this is the letter which I received. I write to Canara Bank.
Yes.
When I receive a request from Capital Corp, Canara Bank, Bhavnagar, etc., then there is a reference to the letter of credit. We enclose documents relating to this drawing as required under the terms of the above documentary credit. Your Honor has it somewhere in the middle of the pages. Please handle these documents in accordance with the instructions detailed below. We have enclosed the documents for your acceptance and payment at maturity. Upon your acceptance, please note this, sir. Upon your acceptance, we will negotiate the presented documents under the DC. So we have not negotiated so far. We have sent the documents to them and said that only upon your acceptance we will negotiate. Advise due date and acceptance by authenticated SWIFT tested telex. We have endorsed the documents amount on the reverse of DC. And then at the bottom of the page, payment instructions. In settlement, please credit so and so to our account upon your SWIFT advice and their SWIFT advice to us, with the breakdown of charges quoting reference number so and so. This document is required to the version of uniform customs practice for documentary credits as mentioned in the credit. So we are acting in terms of the UCP. We say that these are the documents which we have received. Only if you clear, we will make the payment. And with that, at page 25 onwards, the documents are enclosed. Now the first document is the bill of exchange. Page 25. That is the first document. Then at page 26, a bill of sale is there. Then page 27 is some notarial certificate authenticating the bill of sale. Then at page 28, this is a communication basically to instruct the master to physically deliver the vessel. So this is the requirement of the documents required column. These documents are in terms of the documents required column. If Your Honor at this stage were to go back to page 11 and see, the first document, I'm just illustrating, I will not read all of them, but just to illustrate, page 11, legal notarized bill of sale in favor of buyer certifying that the vessel is free of all encumbrances, etc., etc. Now that bill of sale, Your Honor will find is at page number 26. So this is the bill of sale which is spoken of here. So this 6 documents which are mentioned at page 11 were, according to us, tendered to us in terms of the letter of credit. So we, upon receiving that, we forward them to Canara Bank. If Your Honor were to see page number, for example, page 177, this is the certificate which is also a requirement of field 46A of the letter of credit. Then at page 30, there is a letter of undertaking. Page 31, there is a letter of undertaking deletion, etc. These are all documents which were required in terms of field 46A, which we received, we forwarded. Now, page 32 becomes very important. Yes. Page 32, dated 1st June 2021. This is from the plaintiff to Canara Bank. So my documents, which I forwarded to Canara Bank, obviously were sent by Canara Bank to the plaintiff, and plaintiff is responding. Please see the subject regarding accepting the documents of vessel so and so. We are accepting the documents. The same will accept by us on arrival of ship, along with present of notice of readiness. Along with present of notice of readiness. Kindly inform DBS Bank Singapore accordingly. We enclose here with addendum number 3, as per which delivery will be on or before 22nd of June 2021. So, two things which emerge from this. One is they are accepting the documents. They are also, obviously, they are aware about the fact that the vessel has not come, vessel is not going to come. And they are also saying that the time for delivery of the vessel is extended to 22nd of June 2021. So on this day, when they issue this acceptance of 1st June 2021, they did not have any document to support physical presence of the vessel or delivery, or a notice of readiness from the owner of the vessel that we are in a position to deliver the vessel. These 2 documents are not there. In spite of that, they say we are accepting the documents. Kindly inform the DBS Bank Singapore accordingly. Now, this is supported by page 33. So Canara Bank receives this communication, and to that at page 33, there is an annexure. Now, this is a format which is provided for. All bankers, when they obtain clearance from their customer, have to obtain clearance in this format. At the top of the page, the name of the bank is mentioned, Canara Bank. Then under that, Your Honor will find annexure to HO circular number so and so, dated 19/5/2021. So this is a requirement of that circular. Format of letter of acceptance of usance documents to be obtained from the importer clients in respect of documents received under LC. Format of acceptance to be obtained from the user client of documents received under LC. This is dated 1st of June 2021. Now, before I read this further, a very lame argument has been advanced by the plaintiff. That bankers do obtain this kind of letters. What is the meaning of this? Now, here is a person who is dealing in vessels worth crores of rupees. They have not even pleaded illiteracy. They are not saying that we belong to some rural area where in respect of some land of ours, the bankers have obtained our signature on a blank piece of paper. This kind of lame explanation has been accepted by the trial court to discard this document and grant relief in favor of the plaintiff. This document, in respect, my respectful submission, completely non-suits the plaintiff. This and the previous page. Dear sir, to branch in charge Canara Bank, Bhavnagar branch. Dear sir, subject, acceptance of documents drawn under import letter of credit number so-and-so for vessel towards import of so-and-so. This bears reference to the documents received under the import letter of credit established by you covering vessel so-and-so as detailed above, and in this regard we hereby tender our acceptance of documents drawn under subject LC without reservations. Confirm the due date of bill as so-and-so, it's blank. Undertake to submit all necessary documents to ensure transfer of funds. Undertake to make payment on due date and authorize you to debit our account on the due date the counter value of the bill amount together with interest and such other charges incidental thereto. This acceptance letter given by us is in continuation of our FLC agreement cum application executed while establishing the letter of credit. Nonetheless, with this document, does it lie in the mouth of the plaintiff to contend that, sir, I have not received the vessel, I have not received the notice of readiness. You yourself agreed that the documents which are being shown to me, I am accepting those documents. Nonetheless, in law, and when I show the UCP, Your Honor will find, and this is covered by several judgments of the Supreme Court, that this requirement of transmission of documents from one bank to another, etc., is subject to the provisions of waiver, etc. So, if there is an entire procedure which is prescribed, that if a document which is otherwise required document to be forwarded is not forwarded, then the receiving bank, here in this case the issuing bank, can raise an issue that, sir, your documents do not require this document, what do you have to say about it? Or for that matter, the issuer can raise an issue that you cannot honor this because this document is not there or this document is discrepant. There are cases where you find that some fraud document comes there. So they may as well say that these documents are not there. But if you choose not to raise an issue, then you are deemed to have waived the requirement. That is the law. So, because this document from the plaintiff disentitles the plaintiff to any relief, and this is a document which the plaintiff has very clearly and cleverly suppressed to obtain ex parte relief. This document has come from the bank, Canara Bank, and Your Honor will find very interesting stand of the Canara Bank. When I show the written statement of Canara Bank, they have taken a stand on paper that this suit is frivolous, etc., etc. When they get up to argue, they'll support the plaintiff. So, because this is all a conspiracy, eventually the plaintiff possibly wants to blame Canara Bank, but they have colluded with each other. So the pleadings show one thing, and the arguments would be completely different. Subject, of course, now they may, but the arguments before the trial court, which are recorded by the trial court, completely support the plaintiff. So this is the document which based on this, Your Honor will find at page 35 a swift message from Canara Bank to us. Yes. At page 35, sir, please see at the bottom of that table, field 77 narrative. This is the message which was sent. Documents for US dollars, so and so under reference number so and so have been accepted to be paid on 19/11/2021. Sir, why 19/11/2021? Because that is the credit period which is available. So once the Capital Corp, number one, negotiates the letter of credit, the defendant number one will receive the money. But Hussain Ispat, the plaintiff, or for that matter, Canara Bank, will be liable to pay only after that credit period expires. So what happens is that premature receipt of funds by Capital Corp paid by us will be reimbursed on the due date by Canara Bank. So Canara Bank will then give the money to us, and in terms of what is agreed between the parties, that amount will be credited to the account of their client. which is Hussain Ispat. This is how the transaction was supposed to flow. Now this says document for US dollar so and so under LC reference number so and so have been accepted to be paid on 19/11/2021. We will remit the negotiated amount as per your instructions on due date, full stop. If the payment due date falls on Saturday or on a non-banking day in India, then the payment will be made on the following banking day. Please avoid duplication. So very clearly, two things emerge. The plaintiff confirms the document, says that you pay, etc., etc. Two communications. One by the plaintiff to the bank, and there is a covering letter. And the bank writing to us saying that this is all cleared now and we will pay you on the due date. Very clearly it emerges from the record. Now, based on this, I released the payment to Capital Corp on 7th of June 2021. This is dated 3rd of June 2021. 4 days after receiving this, on 7th June 2021, I released payment to Capital Corp. The letter of credit is discounted and I release the payment to Capital Corp. Now, sir, on the next page, Your Honor will find page 36. The vessel is nowhere in sight. So again, there is a request for extension of time. Sir, to me, it is very clear that because Capital Corp was not in a position to deliver the vessel, we do not know Capital Corp is not before the Honorable Court. Hussain Ispat is very cleverly or very clearly withholding inconvenient facts. But it is very apparent, and one can easily read between the lines, that Capital Corp is not in a position to deliver the vessel for some reason, but still is wanting the money, obviously, to use that money to get the vessel released. So all these arrangements are worked out, where they said, all right, release the payment. Now, Capital Corp eventually doesn't get the vessel and doesn't deliver the vessel. But from time to time, the time for delivery is extended. At one stage, they realized that Capital Corp is not in a position to deliver the vessel. Therefore, they terminated the agreement. I will come to that. So page 36 is the extension on 22nd June 2021. Expected time of delivery is extended to 15th August 2021. Then on the next page, page 37, it is again extended on 18th August 2021 to 30th September 2021. And the date of cancellation is mentioned as 5th October 2021. So a vessel which was to be delivered in May does not come, the Capital Corp is not in a position to deliver the vessel till at least August, and the date is extended. Then, sir, at page 38, there is an addendum to the agreement, their agreement between Capital Corp on 17th September 2021. Reference to your email dated 17th September 21, request us to cancel the MOA and return back the LC. So they realize that Capital Corp is not in a position to deliver the vessel. We are not in a position to receive the vessel. So a letter of credit which is already negotiated, they inter se agree that we will cancel the MOA and ask for return of the LC. Accordingly, we hereby cancel the MOA dated so-and-so and addendum showing date of cancellation as 5th October 2021. Due to this cancellation, it is mutually agreed that either buyer or seller have no claim against each other and seller is free to sell the vessel to any party, many things, etc. Now, sir, this is in September 2021. The fact is that eventually the vessel does not come. When the time comes, Your Honor remembers November 2021 was the time for payment by Canara Bank to us. The credit period would expire. 19th November 2021. So as that date approaches, a suit is filed, the present suit. And in that suit, an injunction is obtained. So the position today is that because of the injunction, Canara Bank is not remitting the money to us, nor is it recovering the money from Hussain Ispat. I do not know whether they have initiated proceedings against Capital Corp or not. Capital Corp presently is not before the Honorable Court. Capital Corp is therefore the person who has already received the money under the letter of credit, and we are entitled to receive this money from the Canara Bank. Now, this is entirely a matter between me and Canara Bank. We've been dragged to court. And unfortunately, with the greatest respect to the trial court, an injunction has been granted, which in my respect to submission could not have been granted. And I'll take your honor to the results. So these are the documents. Now, Milos, another argument which will come from the other side, which according to me is irrelevant. So as and when it comes, I'll deal with it. Because they say that this payment which is done by me on 7th June 2021, after 3rd June 2021, they had no notice of that payment. That is what they are saying, which is very unlikely. Canara Bank, once it authorizes me, would know that the LC is negotiated. Now, whether Canara Bank has informed Hussain Ispat or not is irrelevant. Their case is that we, for the first time, sometime in October, after this MOU is cancelled, we take a stand, but sir, I have already paid under the letter of credit. There is no question of cancelling the LC. Sir, what happens is that they cancel the MOU and then they say that now you cancel the LC. The LC could not have been cancelled because it's already acted upon, money is already paid. So LC could not have been cancelled. So we said that there is no question of cancelling the LC. So now they are trying to paint us black by saying that, but you are not even informing us for 3 months you paid by negotiation to Capital Corp, etc. Now, because there is no scope for alleging any fraud. Because I am a bank of international repute. For an amount like this, I am not going to engineer such a fraud where I pay money to Capital Corp and then very slyly demand the money from Canara Bank, etc., and dupe them. So, because there is no scope for making that allegation, that is not done. Now, Your Honor may at this stage see one paragraph in the plate, because what has been argued and will be argued before Your Honor, but please see what their case in the plaint is. Paragraph. Paragraph 11 of the plaint.
Thereafter, Mr. Ashit Parikh.
Yes, thereafter, Mr. Ashit Parikh approached plaintiff and conveyed that the vessel was about to sail and reach Alang on or before 22nd June, as promised, etc. Then, sir, I can skip the next paragraph. I want to show a part where, just Your Honor, give me a minute. Just give me 1 minute. Yes, please see para 19 onwards, sir.
In response
To plaintiffs, another letter dated 4th October 2021, defendant number 2 made an endorsement of the plaintiff's copy that it has already sent a swift message on 18 September regarding the cancellation of letter of credit to defendant number 3. Defendant number 2 also sent another swift message on 5th October 2021 and gave a delivery report of the same to the plaintiffs. In the said message, defendant number 2 referred to the earlier
request.
Yes, earlier
request
yet the request made on 18 September 2021, yet defendant number 3 has not issued the confirmation regarding the cancellation of the letter of credit, etc. Now, Your Honor may kindly, before that, see paragraph 11. At page 27,
Yes.
the very first sentence of page. However, the defendant number 2 acted with gross negligence in issuing the swift message contained in the delivery report dated 3rd June 2021. So when they filed this plaint, they are also mindful of the fact that it is Canara Bank which has acted negligently. So their grievance has to be and can only be against Canara Bank. And if they want to sue Canara Bank for the amount which I have paid to Capital Corp, they are free to do it. But today, though their plaint mentions that there was negligence on the part of Canara Bank, the reliefs which are eventually sought are that I should not, please see the prayers in the plaint at page 37, para 30. The Honorable Court may be pleased to declare that the letter of credit as amended from time to time is vitiated by the fraud perpetrated by defendant number 1 upon the plaintiff. So no fraud by me, by the defendant number 1 upon the plaintiffs, and that defendant number 2 is not entitled to make any payment thereunder. The Honorable Court may be pleased to grant permanent injunction restraining defendant number 2 from making any payment under the letter of credit number so and so. The Honorable Court may be pleased to grant mandatory injunction directing the defendant number 2 to return the plaintiff's fixed deposits for an aggregate sum of rupees 16 crores given in connection with the letter of credit. So this is, they were apprehended that the fixed deposit amount will be adjusted against the amount which is covered by the letter of credit. So essentially the entire plaint talks about two things. One, that there was a fraud by the defendant number 1, and 2, that Canara Bank has acted negligently. As far as our role is concerned, Your Honor will at least not find in the prayer any direct prayer against us. But because of the injunction which is granted, today Canara Bank is not releasing the money in our favor. That is how the matter stands. Now, Your Honor, at this stage, may kindly have a look at the UCP by which we are regulated. UCP 600. This is my problem. Which company? The paper.
This is part of the report.
Yes, it is part of the compilation. We'll just give the page number. Your Honor may just give. It starts at page 208. 208. No, I believe it is 208 of the High Court paper book, which 208.
UCP 600.
UCP 600. Now, this is the UCP by which we are regulated. This UCP 600 are the latest. They are 1st July. I can skip all that. Then Your Honor may come to article number. But these are, Your Honor, obviously must have seen this UCP in the past. These are practices which are followed by all bankers and they are binding on bankers. So this is the code which they follow. Then Your Honor will find article 1, where at the bottom of the page, issuing bank, negotiation, nominated bank, presentation, etc. are defined. We are not concerned with that. Then please see article 5. And this is the sentence Your Honor will find in various Supreme Court judgments. Article 5 of UCP 600. I think it must be page number 212 in Your Honor's copy. Document versus goods, services of goods, services or performance. Now, this is the Brahma Vakya, which normally is always, so banks deal with documents, not with goods, services or performance, to which the documents may relate. So I am not, as a banker, concerned with anything else. I am only concerned with the documents. If you tell me that on presentation of these documents, you release the payment, I am bound to release the payment. I cannot beyond a point undertake a scrutiny. Then Your Honor will find on the next page, you see article 7. This is the undertaking given by the issuing bank. These are the undertakings of the issuing bank. Please see last item, clause C. An issuing bank undertakes to reimburse a nominated bank that has honored or negotiated a complying presentation and forwarded the documents to the issuing bank. Reimbursement for the amount of a complying presentation under a credit available by acceptance or deferred payment is due at maturity, whether or not the nominated bank prepaid or purchased before maturity. An issuing bank's undertaking to reimburse a nominated bank is independent of the issuance bank's undertaking to the beneficiary. And because what they will obviously try and emphasize here is that it is only a complying presentation. So because their case is that if the presentation is not compliant, then I could not have paid, and therefore we are not liable to reimburse. That is their case. So it is a matter of eventually a trial, whether the presentation is compliant or not. I'll show that it is compliant prima facie. I'll also show that there is a doctrine of waiver which applies. But the point of the matter is that can today, by an injunction in a suit, can the defendant number 2 be restrained from making the payment to me? Ultimately, if Hussain Ispat were to succeed in the suit, what will happen? I'll be directed to return the money. As far as bank guarantees and letters of credit are concerned, Supreme Court has very consistently said that don't injunct. There are always remedies available, and it is not case of Hussain Ispat that I am not good for my money. So this amount eventually, ultimately in the suit, if they succeed, then there will be a decree against me, which I am good for. So it is nobody's case that they are not going to get the money if ultimately they succeed. So my point here is that today their case on the face of it, I'll show, is absolutely bogus. This entire argument that this was non-compliant. So this is one requirement. Then Your Honor may come to article number 12, which talks about nomination. At 215. Unless a nominated bank is the confirming bank, an authorization to honor or negotiate does not impose any obligation on that nominated bank to honor or negotiate, except when expressly agreed to by that nominated bank and so communicated to the beneficiary. By nominating a bank to accept or a draft or incur or deferred payment undertaking, an issuing bank authorizes that nominated bank to prepay or purchase draft accepted or a deferred payment undertaking incurred by that nominated bank. Receipt or examination of and forwarding of documents by a nominating bank that is not a confirming bank does not make the nominated bank liable to honor or negotiate, nor does it constitute honor or negotiation. So this is as far as the negotiating bank is concerned. Then please see Article 14, standard for examination of documents. A nominated bank acting on its nomination, a confirming bank if any, and the issuing bank must examine a presentation to determine on the basis of documents alone. Your Honor may note these words, on the basis of documents alone. And when we are talking about documents alone, the documents which are mentioned as required documents in a letter of credit are the only documents which a negotiating bank or an issuing bank is supposed to see. Whether or not the documents appear on their face to constitute a complying presentation. So this is an obligation on all three. Your Honor may kindly note this. It is not my obligation alone. A nominated bank acting on its nomination, a confirming bank in this case is Canara Bank, if any, and the not Canara Bank, and the issuing bank in this case is Canara Bank, must examine a presentation to determine on the basis of the documents alone, whether or not the documents appear on their face to constitute a complying presentation. So this is the obligation of all three. Next paragraph, a nominated bank acting on its nomination, a confirming bank if any, and issuing bank shall each have a maximum of 5 banking days following the date or day of presentation to determine if a presentation is complying. This period is not curtailed or otherwise affected by the occurrence on or after the date of presentation of any expiry date or last day of presentation. So I get 5 days within which I have to examine. So does the issuing bank get those 5 days. So it's not that we have unlimited period to sit over the documents and examine, call for information, find out whether the vessel is reached or not. Because trial court says that I should have examined whether the vessel is reached. No, in my respectful submission, that is not, nowhere in law has any such obligation been cast upon a nominated bank. Then Your Honor will find in the next article, Article 15. Complying presentation at page 217. When an issuing bank determines that a presentation is complying, it must honor. When a confirming bank determines that a presentation is complying, it must honor or negotiate and forward the documents to the issuing bank. When a nominated bank determines that a presentation is complying and honors or negotiates, it must forward the documents to the confirming bank or issuing bank. So, sir, if I receive the document as a nominated bank for the purpose of negotiation, then I must forward the documents to Canada. So it is nobody's case that I have not forwarded the documents. And A says that when an issuing bank determines that the presentation is complying, it must honor. So they found the presentation to be complying. Therefore, they sent me a swift message on 3rd June 2021. Now, where is the question of them going back on that? It has already acted on the basis of this presentation. So there is no question of now going back on it and saying that, but sir, you did not send this or that. It was your option. And that emerges from the next article. This is, in my respectful submission, it's something which clinches the entire matter. Discrepant documents, waiver and notice. When a nominated bank, Article 16, Your Honor, when a nominated bank acting on its nomination, a confirming bank, if any, or the issuing bank determines that a presentation does not comply, it may refuse to honor or negotiate. It was for them. I can refuse to honor or negotiate. So that is the first step. So if I do not find the documents in order, I can refuse. When an issuing bank determines that a presentation does not comply, it may, in its sole judgment, approach the applicant for a waiver of the discrepancies. It may, in its own judgment. Therefore, here in this case, Canara Bank will approach the plaintiff for a waiver of the discrepancies. This does not, however, extend the period mentioned in sub-article 14b. So all this has to be done within a period of 5 days. I have to scrutinize forward within 5 days. They have to examine, ask for waiver, etc. So if there is waiver, then what happens? If there is no waiver, then what happens? When a nominated bank acting on its nomination, a conferring bank, if any, or the issuing bank decides to refuse to honor or negotiate, it must give a single notice to that effect to the presenter. No notice is issued here. Then Your Honor will find the notice must state that the bank is refusing to honor or negotiate, each discrepancy in respect of which the bank refuses to honor or negotiate, and 3, that the bank is holding the documents pending further instructions from the presenter, or that the issuing bank is holding the documents until it receives a waiver from the applicant and agrees to accept it, or receives further instructions from the presenter prior to agreeing to accept a waiver, or that the bank is returning the documents, or that the bank is acting in accordance with instructions previously received from the presenter. The notice required in sub-article 16c must be given by telecommunication, or, if that is not possible, by other expeditious means, no later than the close of 5th banking day following the date of presentation. Again, all to happen in 5 days. A nominated bank acting on its nomination, a confirming bank, if any, or the issuing bank may, after providing notice required by sub-article 16c, 3a or b, return the documents to the presenter at any time. If an issuing bank, now this is very important, if an issuing bank or a confirming bank fails to act in accordance with the provisions of this article, so fails to give a notice of discrepancy, does not give notice of discrepancy, so fails to act in accordance with the provisions of the article, it shall be precluded from claiming that the document do not constitute a complying presentation. There is a clear bar. Neither can Canara Bank nor Hussain Ispat today can say that the presentation was not compliant. That is UCP 600. When an issuing bank refuses to honor, or a confirming bank refuses to honor or negotiate and has given notice to that effect in accordance with this article, it shall then be entitled to claim a refund with interest of any reimbursement made. So the entire scheme is that I have to examine the documents forward, etc. And what is very crucial is that if you find any discrepancy, you have to put me to notice. I will put my presenter to notice, in this case, Capital Corp, that sir, this document is missing. What do you have to say? And then communicate further. So possibly to resolve, if doesn't get resolved, then refuse. But if you do not put me to notice, if your understanding is that in spite of all the amendments in the letter of credit and the agreement and shifting of deletion of clause number 7 and addition of clause number 9 in the other, still if you feel that the notice of readiness had to be included in the presented documents, then Hussain Ispat could have told the bank, Canara Bank could have told me. Let's take a situation Hussain Ispat is not consulted. It is still for Canara Bank. Sir, the buck stops at Canara Bank. It is Canara Bank which has to pay the money to me. If they have examined the documents which I have sent to them, and if they've issued a swift message on 3rd of June 2021, sir, I should not be struggling to get my money. I must get my money. It is not open for anybody now to say, if at all there is any problem with the message which Canara Bank has conveyed, and which, according to the plaintiff, I have read that line where they say that there was gross negligence on the part of Canara Bank, then it is something which is to be borne by Canara Bank. It is something which may have to be borne by Hussain's part. But I, as a negotiating bank, this is unheard of, where a negotiating bank is being told that now you are left high and dry, you will not get your money. You will not get your money from Capital Corp, you will not get your money from us. So merely because, according to them, I, while examining the documents, did not raise the issue about notice of readiness, I must then suffer and not get the money which is due under the letter of credit. This is what it boils down to, their entire case, which is not something which is contemplated in law. If there is a discrepancy, if you do not raise that, if you do not point it out, you don't make an issue of it, then you lose your right for all times to come. You are precluded. That is the language. Now, because in this background, please see one Supreme Court judgment which deals with this very aspect. And because I'm showing all this before I go to the trial court judgment, because I want to show to your honor that all this was shown to the trial court, and please see how it has been dealt with. Since I'm in appeal, I must show that the trial court has seriously heard. Now, the Supreme Court judgment in Federal Bank for the court. Copy of Federal Bank. I believe it may not be part. Is it part of the compilation? I thought it's not part of the compilation. Now here in this judgment, 2001 SCC page 663, Federal Bank versus VM Joke. This is a much celebrated judgment, and your honor will find consistently it has been followed. Now here the facts were that Federal Bank, who is the appellant before the court, was similarly situated as my client. A suit was filed against Federal Bank, where the trial court granted an injunction against payment under the letter of credit. An appeal was filed before the High Court. The High Court dismissed the appeal. Matter went to Supreme Court. The Supreme Court has reversed both the judgments and said that nothing doing, I must get my money. That is Federal Bank. Now please see the facts in paragraph number 3. Yes. The appellant, the negotiating bank, received documents from the sellers, which included 5 delivery challans purportedly signed by the buyer's officers acknowledging receipt of goods. The seller sent a bill of exchange for encashment against the letter of credit for 2 crores, taken out by the buyers. The appellant sent the bill of exchange with endorsement of the buyers and letter of credit and the connected documents, including delivery challan, as received from the seller to the issuing bank, and got the genuineness of the documents confirmed. Below the identical facts. Here also the genuineness is confirmed. The negotiating bank then released rupees so and so in favor of sellers after deducting its commission. But the buyers have obtained a temporary injunction against the issuing bank from honoring the letter of credit. This has resulted in the appellant negotiating bank not being able to obtain reimbursement from the issuing bank. The trial court and the High Court, after noting that the negotiating bank has released to the seller the above sum upon certification of the seller's documents by the issuing bank, have thus precluded the negotiating bank from getting reimbursement from issuing bank. One other peculiar feature of the case is that while the appellant negotiating bank was impleaded as a third defendant in the suit, specific relief was not sought against it either in the suit or in the interlocutory application. In fact, it was stated by the plaintiff purchaser that the negotiating bank need not be heard in the interlocutory application, and that the said bank has no locus standi. But the courts below thought it fit to accept this contention and grant injunction under Order 39 Rule 1 of CPC, restraining the issuing bank from paying any amount to anybody under the letter of credit pending the suit. In the plaint or in the interlocutory application, the plaintiff has not alleged fraud or forgery against the negotiating bank. Kindly note this. That has to be against me. Nor even the knowledge of fraud, forgery, which is alleged against the sellers in respect of the delivery challenge. So it was absolutely on facts an identical matter. Now here, the Supreme Court then considers the letter of credit, etc. Your Honor may see paragraph 9 at page 672. Yes. Thus, the letter of credit confirms the rights of bona fide holders of the draft that may be issued by the drawers, sellers, and to honor on presentation of documents or at maturity. This is, it is also clear that the letter of credit is subject to UCP 1983 revision. Sir, we have a different UCP. This is 1983 UCP. Now, one specious ground which normally happens is the trial court says that but Federal Bank was decided in context of a different UCP. Whereas here we are concerned with a different UCP. So we have prepared a table to show that the material terms with which we are concerned for the purpose of adjudication of this dispute are the same under both the UCP. Therefore, I'll satisfy the court that this has to apply on all fours. For the purpose of the main point arising in the case, it is important to note clause 9 of the letter of credit. That clause requires that one of the documents to be produced by the seller for payment should be copies of the delivery challenge cum invoices issued by Jaswant Steel Rolling Mills Private Limited, duly signed by project authorities with an endorsement that the material was recovered in a good condition and indicating the date of receipt of material at site. So this was the requirement of document. In our case, it is notice of readiness they are claiming, which factually is not the issue, but nonetheless. Then please see paragraph 19 at page 675. Sir, I am reading this facts to show that there cannot be a more identical matter than this, and this has completely been brushed aside. The issuing bank, after receiving the documents, wrote back to the negotiating bank in its crucial letter of 23/3/1998 as follows. We have received the above LC in original along with your covering letter. We have confirmed the due date so-and-so, and the documents are in order, and payment of the above mentioned LC will be made on 20th June May 1998. We have verified the certified signatures, etc. So, similar confirmation. Here in our case, it is 3rd June 2021, where Canara Bank issues a SWIFT message. So, a similar confirmation. In other words, the issuing bank certified the signatures and assured the negotiating bank that it would reimburse the negotiating bank on the due date, 20th May 1998. Obviously, the issuing bank proceeded on the basis that the delivery was on 19th February 1998, as stated in the document. On the basis of the above, letter dated 23/3/1998, sent by the issuing bank to the negotiating bank, the letter discounted the bill of exchange drawn from the seller and paid rupees 194, etc. on so-and-so. We paid on 7th. On 24/3/1998, the negotiating bank wrote to the issuing bank that the letter has returned the LC along with confirmation and also the documents. It said that the negotiating bank shall be delivering the documents again to the issuing bank on due date, and the same is written herewith, which you may kindly acknowledge. Then 22, the negotiating bank having parted with so-and-so upon confirmation of the genuineness of the documents by the issuing bank, was waiting to claim reimbursement by the issuing bank on the due date, that is 20th May 1998. In our case, it was 19th November 2009, 21, I'm sorry. But then there was a sudden surprise. It received a letter from the issuing bank on 19/5/2098 that the issuing bank has found on scrutiny in May 1998 that the negotiating bank has not submitted one delivery challan cum invoices issued by sellers duly signed by project authorities with an endorsement. So a document which was a required document was not submitted. That was a case which was set up after negotiation, similar to our case. Now in this background, please see para 27. It was only then that the negotiating bank came to know that though it had been impleaded in the suit as the third defendant, it has been impleaded in the application for injunction. It moved the court for vacating. Sorry, I'm sorry. It has not been impleaded in the application for injunction. It moved the court for vacation of the order, stating that they had sent the letter of credit and documents, including the delivery challenge dated 19/2/78 by the issuing bank for due checking, and that the issuing bank in their crucial letter dated 23/3/98 had certified the genuineness of the endorsement of the letter of credit and the signatures on the documents. Further, the bill of exchange drawn by the sellers against the LC contains signature of the vice president of the buyers. We have already extracted the endorsement, and the delivery challenge were signed by received material in good condition, and two of those endorsements were countersigned by vice president of the buyer with stamp, and that once the issuing bank had certified the above documents presented by the sellers to the negotiating bank, the negotiating bank could not but pay the sellers, and they had paid rupees so and so. The negotiating bank pointed out that no allegations of fraud or forgery were made against it, nor even before even knowledge thereof attributed to it. On this fact, the trial court refused to vacate the injunction in its order dated so and so. This order was confirmed by the High Court. The negotiating bank has come in appeal by special leave. Now, at page para 33, the points for determination. The following points arise for consideration in this appeal. In the context of the need for banks to take reasonable care to scrutinize the documents produced before it for honoring the letter of credit, what is the relevance of UCP code issued by the International Chamber of Commerce, which has here expressly been incorporated in the LC? If in the case of the plaintiff that there is fraud on the part of the sellers in relation to the documents, and if it is not its case that the negotiating bank was guilty of fraud or had knowledge of fraud by the seller, would the negotiating bank not seek reimbursement from the issuing bank as a holder in due course of the bill of exchange against the letter of credit? And three, whether once the issuing bank has certified the documents which were presented to the negotiating bank by the sellers, the said bank could turn around and refuse reimbursement on the ground that on further scrutiny made by it, long after negotiating bank parted with monies, was not correct or was mistaken. Now, the first question, point 1, is answered. It's relevant because we are completely guided by UCP. Para 38, we are concerned with the Uniform Commercial Practice Documentary Credit 1983. Then Article 3 is reproduced on the next page. Para 40, Article 10 is reproduced, 11 is reproduced. Then Para 41. We have to refer to another important article, Article 15, which concerns the reasonable care with which documents have to be examined. This article has relevance to the question of fraud. It refers to the safeguards to be taken by the bank. It states, bank must examine all documents with reasonable care to ascertain that they appear on their face to be in accordance with the terms and conditions of the credit. Documents which appear on their face to be inconsistent with another will be considered as not appearing on their face to be in accordance with terms and conditions of the credit. Once the bank takes reasonable care as above, Article 16 states that the bank will have to be reimbursed by the party giving such authority. Clause B of Article 16 states that refusal by the issuing bank to pay must be on documents alone as appear on their face to be inconsistent with the terms and conditions of the credit. Those first line after the reproduced paragraph is very important. Once the bank takes such reasonable care. So here in our case, I have taken reasonable care to first of all take their confirmation and then pay. Para 42. At common law, the position is no different. The principle of reasonable care has been applied by Lord Diplock in so and so. The bank has to examine with reasonable care to ascertain if they appear on their face to be in accordance with the terms and letter of credit. In that case, the reference was made to Article 7 of UCP 1962. It was observed that the state article did no more than restate the duty of the bank at common law. It was further held that in the ordinary course, visual inspection of the actual documents presented is all that is called for. In Bas versus so and so, the defendant bank was instructed to negotiate the drafts of a shipper in Sydney against certificate of Dr. So and so for 100 tons of so and so. The shipper shipped worthless core, which was described in the bill as so and so. The sample initially submitted did not refer to the bill of lading goods, but later the shipper made the sample in the same way as the goods were described in the bill of lading quantity and obtained the second certificate showing certificate test of a sample of so and so. The bank this time accepted the shipper's draft and was held to be entitled to recover from the plaintiff. The certificate on its face was regular and the same within the meaning of its mandate on the face. Then next paragraph. One another important article that is important on the question is of reasonable care is of the bank in examining the document is Article 17. It reads, banks assume no liability or responsibility for the form, sufficiency, accuracy, genuineness, falsification, or legal effect of any documents or for the general and or particular conditions stipulated in the documents or superimposed thereon. Because we are not concerned with a case where a document is found to be bogus or a forged document. So all these observations about them appearing to be proper on face, etc., are not relevant for our purposes. Here is a case where their only case is that when no notice of readiness was available in the documents forwarded, how did you negotiate? That is the only case. Then please see paragraph 47.
Forty.
46 and 47. At page 6, in deciding whether the time taken is reasonable or not, English courts used to take into account banking practice. Your Honor has it in 46. Then 47. Clause D of Article 16 of 1983 division states that if the issuing bank decides to refuse, it must give notice to the bank from which it received the documents or to the beneficiary. Sir, I have read there is a similar article in UCP 600. Now, because when I say that there is no material difference, because UCP, which was under consideration here, also made a provision that if you find a discrepancy, notify. Similarly, there is a provision here that if you find a discrepancy, notify. So those provisions are similar. Now, in that context, Supreme Court says it must give notice to the bank from which it received the documents or to the beneficiary. If it directly received from him, such notice must state the discrepancies in respect of which the issuing bank refuses the documents and must also state whether it is holding the documents at the disposal of or is returning them to the presenter, remitting bank, or the beneficiary as the case may be. Subclause E reads, if the issuing bank fails to act in accordance with the provisions of para C and D of this article and or fails to hold the documents at the disposal of or to return them to the presenter, the issuing bank shall be precluded from claiming that the documents are not in accordance with the terms and conditions of the credit. At this stage, if Your Honor sees exactly worded Article 16 subclause G, F. Sir, the gist of F, because I'm showing this because I think there is an argument which will come from the other side that, sir, we have 16E in UCP, which we are concerned with, it is 16F. Please compare 16F with this 16E, which is reproduced in Supreme Court. If an issuing bank or confirming bank fails to act in accordance with the provisions of this article, it shall be precluded from claiming that the documents do not constitute a complying presentation. This is our UCP. Now, please compare this with 16A. If E at page paragraph 47, if the issuing bank fails to act in accordance with the provisions of para C and D of this article and or fails to hold the document at the disposal or return them to the presenter, the issuing bank shall be precluded from claiming that the documents are not in accordance with the terms and conditions of the credit. So identical, the sum and substance is that you then barred from raising this issue. This subclause E of Article 16 thus, where the issuing bank does not respond with reasonable time, it cannot under UCP dispute the documents later. This is the sum and substance of it. Yes. This subclause E of Article 16 has been relied upon heavily by the learned counsel for the appellant to show that where the issuing bank expressly accepts the documents sent by the negotiating bank, no other question can arise. As to what type of documents are to be accepted as originals, 22C states that unless otherwise stipulated in the credit, banks will accept as original documents produced or appearing to have been produced by a reprographic system, etc., etc. Sir, we can skip that and then straight away go to paragraph number 54. So, the Supreme Court says that UCP, they are binding, also interprets the UCP and gives it the meaning that it is supposed to have. And then at page 6085, decides the other 2 points. We have set out the facts in sufficient detail to highlight that the plaintiff buyers have no plea that the negotiating bank which paid the monies to the sellers committed any fraud. The allegations in the plaint are that the sellers in connivance with some persons presented forged or false documents to the negotiating bank, which included delivery vouchers purported issued and signed on behalf of the buyers, signed by one Mr. So-and-so and countersigned by so-and-so. The case of the buyers was, however, that Mr. Bhavnagar was not in their service nor authorized to issue any such vouchers. In several judgments of this court, it has been held that courts ought not to grant injunction to restrain encashment of bank guarantee or letters of credit. Two exceptions have been mentioned. One, fraud, and second, irreparable damage. If the plaintiff is prima facie able to establish that the case comes under these two exceptions, temporary injunction under Order 39 Rule 1 CPC can be issued. It has also been held that the contract of bank guarantee or the letter of credit is independent of the main contract between the seller and the buyer. This is also clear from Article 3 and 4 of UCP 1983 revision. In case of an irrevocable bank guarantee or letter of credit, the buyer cannot obtain injunction against the banker on the ground that there was breach of the contract by the seller. The bank is to honor the demand or encashment if the seller prima facie complies with the terms of the bank guarantee or the letter of credit. Namely, if the seller produces the documents enumerated in the bank guarantee or the letter of credit. If the bank is satisfied on the face of the documents that they are in conformity with the list of documents mentioned in the bank guarantee or the letter of credit, there is no discrepancy. It is bound to honor the demand of the seller for encashment. You know, pausing here for a moment, if we apply this to our facts, if the bank is satisfied on the face of the documents that they are in conformity with the list of documents mentioned in the bank guarantee or letter of credit, the list of documents would be filled 46B, the 6 documents, not the 7. While doing so, it must take reasonable care. It is not permissible for the bank to refuse payment on the ground that the buyer is claiming that there is breach of contract, nor can the bank try to decide this question of breach at that stage and refuse payment to the seller. Its obligation under the document having nothing to do with any dispute as to breach of contract between the seller and the buyer. As to its knowledge of fraud or forgery, we shall presently deal with it. Knowledge of fraud. Decided cases hold that in order to obtain an injunction against the issuing bank, it is necessary to prove that the bank had knowledge of the fraud. Here, there is no such case. So this is what the Supreme Court says. Then we can skip up to paragraph number 58 and see 58, see 59. Look at 688. Applying the said principle, we may state that if the appellant bank, federal bank, was merely a collecting bank or agent which had approached the Bank of Maharashtra, the issuing bank, and if the issuing bank was sought to be restrained by the buyer before payment was made by the issuing bank to the Canara Bank, the collecting bank could not have compelled the issuing bank to release the money or collection if the buyer informed the issuing bank in his claim that the documents to be presented to it by the collecting bank were forged or fraudulent. But where, on the other hand, the negotiating bank, that is the federal bank, has said on the basis of a clearance given by the issuing bank, this is very crucial, given by the issuing bank as to genuineness of documents and seeks reimbursement, then the negotiating bank is in the position of a holder in due course. Please note this, is in a position of a holder in due course and claim that the suit of the buyer must fail if it sought to restrain the issuing bank from reimbursing the negotiating bank. This principle's prima facie flow from so-and-so judgment, which has been followed both in England and by this court in several cases. The contract between the issuing banker and the paying or the negotiating intermediary banker may partake of a dual nature. The relationship is mainly that of principal and agent, mandator and mandatory. In order that he may claim reimbursement for any payment, he must, under the credit or the indemnity of an agent, the intermediary banker must obey strictly the instructions he receives, for by not acting on them, he accepts them and thus enters into contractual relationship with the issuing bank. The instructions may take the form of an authority either to pay against documents or draft accompanied by documents, or to negotiate drafts drawn either on the issuing banker or on the buyer. The authority may be accompanied by instructions to the intermediary banker to confirm the credit, that is, to place himself in binding contractual relationship with the beneficiary. There is ordinarily no privity between the intermediary banker and the buyer, but the intermediary banker, though initially the agent of the issuing bank, may also act on principal in relation. Then there are 2 or 3. Then please see paragraph 65. This is how the Supreme Court summarized it. Summarizing, we hold that when the plaintiff buyer has no case that the appellant negotiating bank had any knowledge of fraud, and it took precaution in getting the clearance for the document from the issuing bank on 20th March 1998, and such clearance was given by the letter, it was not opened by the issuing bank to contend that on fresh scrutiny in May 1998, it found that the documents were not in conformity with the letters of credit. So 2 requirements, only 2 things to be seen in such matters. One is whether there is any case of fraud against me or knowledge of fraud. You can say that yes, I was party to the fraud. That Capital Corp wanted to defraud Hussain Ispat, so they conspired. And I was part of that conspiracy. I had this conspiracy. It's absurd. There is no such case. Even if any such case were set up, it would have been absurd because a bank of international repute would not get involved in such prima facie. Ultimately, they may plead and prove, that's a different matter. So that is one. And the second thing with the Supreme Court says is that if it is found that the issuing bank has confirmed and the payment is in pursuance of an issuing, then issuing bank cannot be restrained from reimbursing the negotiating bank. So 2 things very clearly emerge from this judgment, because I believe that there is no need for examining any other case law. This federal bank judgment is fairly applicable to the facts of the present case. So Your Honor may in this background see 2 things. One is what is the, yes. We have prepared a chart, not required, but for Your Honor's convenience. We have prepared a chart of comparison of the UCP. Yes, sir. But the facts in federal bank, we have prepared 2 charts. One is this federal bank judgment, what were the facts? And what is that the Supreme Court held, and against each. For example, position of parties is also the same. We are also a negotiating bank. Applicable UCP, there was 1983 revision, it is UCP 600 here. Letter of credit date, etc. So we have given a tabular statement of the similarities in the matter before the Supreme Court and the matter before Your Honor. Just to emphasize, the idea is to emphasize this point that there cannot be a matter more covered by a Supreme Court judgment than this. That is our endeavor. So this is, and the second chart which we have prepared is of the similarities between the 2 UCPs, because we are giving this because it has also been a contention which has been accepted by the trial court that because the 2 UCPs are different, we will not apply the law of federal bank. So in this background, 2 things I would like to show before I conclude my arguments. First is what is the plaint now? What are the elements in the plaint? And then some findings of the trial. I'll go as per the paragraphs. Ultimately, Your Honor is today concerned with the case which is set out in the pleadings. Things may, everybody improvises, but therefore we need to go back and touch base and find out what the pleadings are. So, it's the first paragraph onwards, they give relationship between the parties. There is a reference to MOA. But that goes on up to, I am on, can I go by the paragraph number? Because my page number is slightly different. So up to paragraph number 10, which would be page 11 of the compilation which Your Honor has.
Once again, paragraph number 10.
Yes, paragraph number 10. Once again, letter of credit was amended. Then we can see 11. Please see 11. Thereafter, Mr. Ashit Parikh approached plaintiff number 2 and conveyed that said vessel was about to sail and reach Alang on or before 22nd June as promised by defendant number 1 and duly recorded in the third addendum to the MOA. He further conveyed that defendant number 1 needed a letter from the plaintiff to enable them to secure the early release of the said vessel. So this is very important. My case that this entire thing was done basically to facilitate early release of the vessel, which was embroiled in some litigation there. He also conveyed that such letter will not create any further liability for the plaintiffs, and the plaintiffs would be required to pay only as per the terms and conditions of the letter of credit. With his help and according to his instructions, the plaintiffs addressed a letter to defendant number 2, the draft of which was actually dictated by Mr. Ashit Parikh on 1st June 2021. In the said letter, it was stated as follows. Now, as I said, on 1st June, Your Honor has seen those documents. 1st June, there is a printed format. There is no reference to that printed format only. But kindly have that compilation again, because there is a very, very important argument, which is this letter, which is referred to in this paragraph. Your Honor will actually find at page number 32 of the compilation. Page, the short compilation.
Today it is
Yes, the one which I've been.
exhibit B.
Yeah, page 32.
Yes.
So
Hussain
this is the
Ispat.
letter.
Hussain said is part.
Correct. So the reference in paragraph number 20, this paragraph which I was reading, we are accepting the documents, etc., is this letter. So the plaintiff comes out with a very lame argument that one Mr. Ashit Parikh told me that you write this letter. He prepared the letter and I have signed on the dotted line. So that is as far as this letter at page number 32. This is how they explain in the plain. Nonetheless, here, this letter is actually preceded or accompanied by page 33 of this compilation. There is no reference to page 33. Because this is very important, because when a plaintiff suppresses material facts or misleads the honorable court, it's a ground for not granting injunction. So this page 33 is a document which is not referred to in the plaint at all. This is a document which comes from the custody of the bank. For the bank, for some reason, produces this document. So the plaintiff who should have produced this document at page 33 and explained that document in the plaint does not do it, clearly suppresses and withholds the document, and then very conveniently explains this document at page 32 as saying that I was told by one Mr. Ashit Parikh that you issue some such letter, it will not affect your right business, etc. As if they are some fly-by-night operator. They are one of the largest shipbreakers here in Bhavnagar. They are doing business worth crores of rupees. We do not know. They are possibly bringing in ships every month or maybe quite a few in a year. So these are not persons who do not know how business works. They are educated people who say that somebody told us you write this, and because this kind of lame excuses are accepted to deny me my money under the letter of credit. That is what is falling for your Honor's consideration. So coming back to this paragraph. So 1st June letter is reproduced. Then after the reproduced letter, from such letter it is clear that the plaintiff conveyed that the document are in order and we are intending to and will accept them when the ship has arrived at Alang and when notice of readiness is presented. The letter of 1st June 2021 written by plaintiff conveys beyond any reasonable doubt that the plaintiff intended to and will accept the documents when the ship has arrived at Alang and when the notice of readiness is presented. This reflected the agreed terms of the MOA and letter of credit as well as usual commercial practice and custom prevailing at Alang, and the same was or ought reasonably to have been known to defendant number 2. However, defendant number 2 acted with gross negligence in issuing the swift message contained in the delivery report dated 3rd June 2021. So, sir, 1st June letter, which is at page 32 of the compilation, this is how they explain. Now, can this explanation stand? Because they are trying to take advantage of some language issues in the letter. It may not be very well worded letter. So they are trying to take advantage of the language issues. So let's give them that benefit. But with the letter at page 33, which the bank has produced, where they very clearly say, because this page 33 letter does not mince words. It very clearly says, please see 33 again, paragraph number Roman 3, undertake to submit all necessary documents to ensure transfer of funds, undertake to make payments on due date and authorize you to debit our account on the due date the counter value of the bill amount together with interest and such other charges incidental thereto. So, Milos, in terms of the UCP, I gave a notice to Canara Bank. Canara Bank wrote to Hussain Ispat, we do not have that. How did they communicate inter se, we do not know. But Canara Bank, first of all, gets this letter at page 33, which is in context of the notice which is given by me in terms of the UCP that I have received for negotiation this letter of credit. What do you have to say? The bank receives this, and along with this receives page 32. Now, page 32, they are trying to read it to mean we are accepting the documents, the same will accept by us. Now, this is a language issue. I do not know what they mean. Will accept by us on arrival of ship, along with present of notice of readiness, kindly inform DBS Bank Singapore accordingly. So, are they trying to say that we put the bank to notice that this is a discrepancy? If this was there was a discrepancy, then this communication would have very clearly said that, sir, there is no notice of readiness. Therefore, why are you permitting negotiation? Do not permit negotiation. On the contrary, they say, we enclose here with addendum number 3, for which delivery will be honored before 22nd June. This is for your kind confirmation. Now, when the UCP says that a discrepancy has to be very clearly pointed out, if it is not pointed out, you would deem to have waived. Now, this is a correspondence or communication between the issuing bank and the issuer. The issuer now very conveniently says that look at this document at 1st June 2021. This has wrongly been construed by my banker. And there is gross negligence on the part of my banker, clearly suppressing the document at page 33. When 33 and 32 are read together, because my submission is that there is no scope for any other construction. The only construction which is possible is that the issuer, Hussain Ispat, permitted Canara Bank to issue a communication, once again permitting me to negotiate. That is the only interpretation which is possible. But in plain, this is the interpretation which is placed. So, Milos, two arguments which emerge from paragraph 11. One is that their entire case, which is set up in paragraph 11, completely suppresses the document at page 33. With the reading of, if 33 is read with 32, no scope for this interpretation, number one. Assuming there is some scope for this interpretation, their own case is that it is Canara Bank which has been negligent. So this is their pleading. Now, reading further, sir. Paragraph 12. Defendant number 1 was still unable to deliver the said vessel on 25th June as promised. Under the circumstances, 4th amendment came to be, etc. So then they talk about the amendments. Sir, here also there is no allegation up till here. There is no allegation of fraud by Capital Corp. That Capital Corp, fraud will have to be, the fraud will have to be this, that Capital Corp knew from day one that it is not in a position to deliver the vessel, because prior intention is relevant for the purpose of fraud. So the pleading will have to be that Capital Corp knew that I don't have the means to deliver this vessel. Still, it entered into this contract, extracted a letter of undertaking, a letter of credit from Hussain Ispat, thereafter managed with the two banks and got the money released, and now is not in a position to deliver the vessel or pay. So the fraud which has to be pleaded has to be this. They are here saying that we entered into an agreement, time limits are extended, we found that he is not in a position to facilitate, we did all this. Then paragraph 13. Extensive correspondence, etc. Again, Milos, para 13 does not talk about fraud. Then para 14 may kindly be seen. In view of the aforesaid and the constant false promises given by defendant number 1 and their agents about delivery of the said vessel, the plaintiff finally wrote a letter dated 15 September 21 to defendant number 2 regarding cancellation of the letter of credit. The plaintiff stated inter alia that they wanted to cancel the letter of credit bearing number so and so. Although defendant number 1 still kept on promising that the said vessel will be delivered and that they are attending to the procedure for lifting confiscation order, finally the plaintiff and defendant number 1 entered into 6th and final amendment of the MOA on 17th September 2021. By virtue of the same, both the plaintiffs and defendant cancelled the MOA. Now, Milos, your honor has seen that document of cancellation. It is part of this compilation, new compilation which I have given. Because there they have very clearly said that both parties will not have a claim against each other. So there is no scope for pleading fraud. It is not pleaded. It is not a case of fraud. It is clearly a case where yes. I'll just complete the reading and then offer my comments. Paragraph 15 talks about the other amendment, etc. Now, as we read further, para 21 may kindly be seen. The plaintiffs have reliably come to learn that defendant number 1 and their agents have played a systematic, egregious fraud upon the plaintiffs. Defendant number 2 has purported to sell the said vessel when it was not of their ownership and without disclosing that the same was subject to the confiscation orders. So, pausing here for a moment, please see how the plaint runs. It talks about events up to termination. So it is not their case that the original agreement itself was executed as a byproduct of fraud. Then they say that after all these events, now we realize that defendant number 1 and their agent has played an egregious fraud. Yes. Yeah, I'm sorry. Para 21 I was at. Purported to sell the said vessel when it was not of their ownership and without disclosing that the same was subject to confiscation orders. The plaintiffs addressed a detailed letter on so-and-so. The plaintiff clearly stated inter alia as so-and-so. Moreover, as per then they talk about para 22. Defendant number 3 surprisingly claimed on 22nd October that they do not agree with the cancellation of the said letter of credit, and they have discounted the letter of credit on the basis of swift message and delivery report dated 3rd June 2021 sent by defendant number 2. Defendant number 2 sent a swift message on 29th October 2021 to defendant number 3, clearly stating inter alia that MOS stands cancelled by the consent and that even defendant number 1 has requested defendant number 3 to confirm cancellation of the letter of credit. Moreover, as per the letter of credit, the payment terms were 150 days from the date of the physical delivery of the vessel. Since the plaintiffs have not received delivery of the said vessel, defendant number 3 was required to cancel the letter and issue confirmation. How can they contend this after the amendments, where they themselves did away with the requirement of physical delivery of the vessel? So this is the kind of case which has been put up by the plaintiff. Also wrote a letter dated 30th October to defendant number 1 in response to their email. Defendant number 1 promised that the letter of credit would be cancelled by next week, and they were arranging for payment. The plaintiff stated that till that date, defendant number 1 has never mentioned about making payment, etc. So, this is then the narrative post the termination. Yes. And then, para 26. Since the defendant number 3 refused to confirm cancellation of the aforesaid letter of credit, and since the tentative due date for payment 19th November, it has become necessary for the plaintiff to file the present suit. So this is their cause of action. This is the reason why they have come. Now, not a word against me about fraud. And except for saying that there is an egregious fraud played by defendant number 1 and the agent. Sir, what actually has happened is this, as it emerges from the record. This is how I see the entire matter. That there was an agreement for sale of the vessel. They were hoping to get the vessel. The vendor was hoping to get it released from whatever litigation it was in, get the confiscation orders removed, etc. At some stage, the vendor must have said that, please, I need money to get all this confiscation, etc. removed. Therefore, all this amendment of LC agreements, whereby notice of readiness, part delivery, all those clauses are done away with. Money is released. He receives the money. Still, he is not in a position to deliver the vessel, and they terminate. Now, after termination, it was for Capital Corp to return the money to the plaintiff. The Capital Corp does not return the money to the plaintiff. Now they are trying to somehow put me in a fix by saying that now you are not entitled. This is how the entire matter stands. Now, it is the cause of action, paragraph page 28, para 28. The cause of action has arisen in the aforesaid facts and circumstances when the MOA came to be made on 21st April 2021, and when it underwent 6th amendment from time to time, and also when at the request of the plaintiffs, the defendant number 2 issued to aforesaid letter of credit, and also when defendant number 1 failed to deliver the said vessel, and also when the plaintiff subsequently discovered that defendant number 1 has perpetrated a fraud upon the plaintiff And also when defendant number 1 misrepresented to plaintiff that it was the owner of the said vessel. And also when defendant number 1 did not disclose that the said vessel was subject to order of confiscation in Indonesian court. And also when an addendum on 7 September 2021, the plaintiff and defendant number 1 agreed to cancel the MOA and also to cancel the aforesaid letter of credit. And also when the plaintiffs thereafter repeatedly wrote letters to defendant number 1 and 2 in connection with cancellation of letter of credit. And also when defendant number 1 went on promising that they will obtain confirmation of cancellation of letter of credit from defendant number 3, and also when they failed to obtain such confirmation, and also when defendant number 3 with a email dated so-and-so disclosed that they will not agree to cancellation of the letter of credit, and thus when the plaintiff strongly apprehended that defendant number 3 will try to invoke encash and demand payment under the aforesaid letter of credit. Also when neither defendant number 1 and 3 are entitled to demand such payment from defendant number 2, he is liable to make such payment, and also when the aforesaid letter of credit stands cancelled and null and void on account of fraudulent actions of defendant number 1 and their agents, and also when the plaintiffs have now become entitled to file the suit for declaration, permanent injunction, and other release. So this is their cause of action. Nonetheless, it was argued before the trial court, it will argue before your honor, that look at us, we have become victims here. We have not received the vessel, our money is gone, we are in a helpless condition, and therefore some plea of equity will be raised before your honor. My submission is that this is a matter concerning letter of credit, first and foremost, where we are completely regulated by the UCP 600, which has now been interpreted by the Honorable Supreme Court consistently over a period of time, that it is binding on the bankers. It is a code by which they are completely governed. So if in terms of the UCP, I am entitled to the payment, the consequences of that upon the plaintiff cannot be a ground for denying me the payment if I am entitled to one, which in my respectful submission I am entitled to. So that is one. Now, the second part of the matter, again on merits, is in two parts. First is whether I have actually committed any breach of the UCP. When I did not, I sent only 6 documents and not the 7th. My submission is that if you look at the letter of credit, and I have been emphasizing this, that we no need to go to it again. But if you look at the letter of credit, the requirement, documentary requirements after the various amendments were only 6. The 7th has clearly been done away with. So as a negotiating bank, I look at the documents required column and see that, yes, according to me, on the face of it, again, the Supreme Court says detailed scrutiny, etc. is not possible. It's a matter of 5 days only. So if I receive the documents, it's not that I get indefinite time to scrutinize. I look at on the face of it, see the description in the documents required column, see the document and find on the face of it that they are fine. Then I don't immediately make the payment. I send them to the issuing bank. So when today, what is my action which is being tested? My action which is being tested is that I received the documents and I forwarded them to Canara Bank, being satisfied that there is no discrepancy. So the scrutiny of my documents was not preceded by reasonable care. That is their case. So I have not been careful in examining whether these documents are discrepant or not, or whether there is any missing document. This is not a case of discrepancy. So if a description of a document in the letter of credit is one, whereas the description of the document which is placed before me is different, then there is a discrepancy. Such discrepancy is not there. Here is a case where a document, according to them, which should have formed part of the presentation, is not there. Now, my action which is under scrutiny is whether had I exercised reasonable care or not. My submission is therefore that when I receive documents and find that they confirm with the documents required column and I forwarded it, I have exercised reasonable care. That is my first submission. My second submission is that, assuming for the sake of argument, that I was a little careless there. Let's assume for the sake of argument. And of course, a lot of noise will be made that I should have done this, that, etc. Ultimately, there is no vessel, there is nothing, and because of this, we end up high and dry. Therefore, a great amount. Now, the law does not require a banker to examine or scrutinize a document beyond the point. The law, as Federal Bank discusses is that I have to see the documents on the face of the documents. If I find discrepancy, then I have to raise. So, my lords, my role is very limited as the first party receiving the document. I'm the first person in point in time who's receiving the document. So my role of reasonable care and precaution will have to be tested or viewed in background of the fact that I am only the person who initiates the entire transaction by receiving it from the presenter. I thereafter forward it to the issuing bank, who then in turn forwards it to the issuer. So in that background, so if at all there is any lapse on my part, it is going to be corrected by the issuing bank. If not corrected by the issuing bank, it will be corrected by the issuer. So this entire argument of care and caution to be exercised by me will have to be seen in this background. So if I have received the documents in terms of 46B and I have forwarded, I have exercised reasonable care and caution. Once that is found, prima facie, for the purpose of injunction cannot be denied, must be denied, and there is no question of granting injunction. Having said that, my argument on a demurrer is that assuming for the sake of argument that there is some scope for arguing that no, I did not exercise reasonable care, then the waiver article comes into play. So today, there are basically, when faced with that situation, that UCP clearly talks about waiver, Federal Bank interpreting UCP says that this is binding, issuing bank, etc. They come out with an argument to answer this argument of waiver. But sir, look at the fact that page 32 document, which is part of this 1st June communication, according to us, has wrongly been construed by my banker. So that is a matter between you and your banker. It is not something which concerns me. If you feel that your banker has wrongly construed the document, then it is something which you need to take up with your banker. So that doesn't take the matter any further. Then they come out with this argument when faced with the situation that is not the only document. Page 33 is also there, which comes from the custody of the bank. So when faced with that situation, they come out with this desperate lame argument that, sir, these are bankers, we have to sign on the dotted line. If they say you sign here, we will sign here. And that is something which has been accepted by the trial. And so my submission is that this is not a matter in which an injunction ought to have been granted. Now let us see the reasons which are weighed with the trial court for granting the injunction. The order starts at page 66. Must say, because every contention has been very correctly noted. The reasons start at page 109. Whether prima facie case balance issues. Then, Your Honor, I may take. Then there is a narrative. The arguments are reproduced. The first finding of the trial court, Your Honor, will find at page 114. 114. Yes. About somewhere in the middle of the page, there are total 5 amendments in MOA. It is a classic case because there are 5 amendments in MOA and it is for change of date of delivery of vessel. One can easily infer that the defendant number 1 was neither in a position to deliver vessel nor wanted to deliver the vessel, and he wanted to commit fraud with the plaintiff. Is a fraud ever a matter of inference? This is the finding, first finding. Fraud can never be a matter of inference. For fraud is a matter of pleadings and evidence. That is one. It also appears from the pleadings and arguments of the plaintiff that when defendant number 1 has not delivered vessels from time to time and expected time, the plaintiffs had inquired about the vessel and they came to know that the vessel is already in confiscation by Indonesian court. Then after plaintiff also came to learn that the said vessel was never of the ownership of defendant number 1 at any point of time. Thus, it is a clear prima facie case of fraud committed by defendant number 1. So first of all, a person who is purchasing a vessel of this value and who is regularly doing this business, can't be permitted to come up with such a lame argument. He is bound to have examined the title of the vessel, the possibility of the vendor being able to deliver the vessel, give a complete and clear title to it. So, because this businessmen don't enter into transactions in casual manner, where you simply somebody says that I am in a position to deliver. All right, fine. Then I will issue a letter of credit. It doesn't happen that way. Therefore, trial court has very clearly erred by coming to a conclusion that it is a case of fraud. So, first of all, when plaintiffs have made correspondence with defendant number 1 and ultimately the MOA was cancelled by virtue of addendum number 6 on 17/9/21, thus it prima facie appears that the intention of the defendant number 1 was to commit fraud with the plaintiff by not delivering the vessel to the plaintiff. With the greatest respect, requirement of fraud, we can go to the provisions of law. A fraud, one has to say that there has to be an intention at the very outset, etc. This can't be, because this is not the manner in which you prima facie record fraud. Now the question is that whether the fact of fraud was in the knowledge of defendant number 3 or not. Defendant number 1 was carrying on his business at Singapore, and defendant number 3 is also situated at Singapore. Before discounting the letter of credit, it was the duty of defendant number 2 to inquire whether defendant number 1 had delivered the vessel to the plaintiff. Where do we get this from? The LCs have been amended. The time for delivery is being extended from time to time. In the previous paragraph, the Honorable Court comes to the conclusion that 6 amendments have been taken place to extend the date of delivery. So where is the obligation on me to find out? But where do we get this obligation in law from? Upon a negotiating banker or not? But defendant number 1 has not inquired into it about it. Moreover, defendant number 3 financed to defendant number 1 in pursuance of letter of credit. Therefore, the question arises that on what basis defendant number 3 financed to defendant number 1? Defendant number 3 has not taken any reasonable and due care before financing to defendant number 1. Because what is this? A letter of credit is a negotiable document. Any banker is bound to negotiate. It is something happens every day, every minute of the day. Some or the other letter of credit is being encashed or negotiated. Where do we get this requirement from? Before financing to defendant number 1. Therefore, it is prima facie presumed that defendant number 1 was in knowledge of the fraud. Please see, Millers. This is how knowledge of the fraud is to be imputed to me. On one hand, you say no care, no caution before financing. Then you say presume. Third, you say infer. And you come to a conclusion, jump to a conclusion that therefore a fraud is committed and I'm in knowledge of the fraud. This is with the greatest respect. These are not the findings which can be sustained in law. So this is one finding. Then Your Honor will find on the next page 117. Second paragraph. Then after, in field 47A, additional condition, it is mentioned in point number 8 that the seller shall have issued notice of readiness for delivery only after the vessel has arrived at a safe anchorage along India and is ready for effecting physical delivery. Thus, it clearly transpires that notice of readiness was must. No doubt, letter of credit is a contract between bank and the parties are not concerned, but the terms or conditions of the letter of credit is to be fulfilled and is to be respectful. And if the terms and the conditions fulfilled, then letter of credit can be encashed. Then after letter of credit was amended on 4/5/2021 and field 46B, point number 7 was amended as that the buyer has received a notice of readiness from the seller or seller's agent at Alang that the vessel is ready to be delivered physically to buyers and all other terms and conditions remain the same. The plaintiffs have informed the amendments in letter of credit to the defendant number 2 on so and so. Again, letter of credit was amended on so and so. It appears that the defendant wrote a letter to plaintiff on 21/5 and instructed letter of credit in 46B, field 7 to be deleted. In additional condition 47A, following to be added, document to be presented after receipt of an authenticated SWIFT message that the buyers have received notice, etc. And accordingly, letter of credit was amended on 24/5/2021. Thus, by virtue of this amendment, point number 9 was newly added, but other terms and conditions remain the same. In mark 3/1/11, in field 46A, point number 7 was deleted and point number 7 was added. Thus, by making all these changes, defendant number one wanted to encash the letter of credit by committing fraud. How? We do not know. Sir, the change which the learned judge is talking about is when you remove the requirement of notice of readiness, etc., from the required documents field to other conditions, the idea was to commit fraud. Now, this is a very slightly tricky, nuanced issue. That on one hand, you say that the defendant had the intention to commit fraud. So, defendant with an intention to get the money by removing one condition from one field and getting it added in another, what does he do? He does away with the requirement of a document in the form of a notice of readiness. So, you accept in a way my contention that the requirement of that document in the required documents column is done away with. Learned judge says that it has been done away with by the defendant number one because it was his fraudulent intention that if that particular condition is done away with, then I don't have to produce the notice of readiness. If I don't have to produce notice of readiness, I'll get the money without that document. Now I have released the money without that document and you're finding fault with me. But if it was never the requirement, how do you find fault with me? Therefore, I'm saying that when the learned judge accepts this argument of the plaintiff, that the defendant number one always had a fraudulent intent to do what? Receive money without producing a certain document. That was his fraudulent intent. So he does away with these requirements of producing that document. So if on one hand you are accepting the case that the requirement to produce that document has been done away with, then how do you say that by releasing the money under the LC without that document, I have committed some act of negligence, or that I have not taken sufficient care and caution? So this is how the findings are also mutually inconsistent. The case is mutually inconsistent. Looking to original letter of credit, point number 7 was that the buyers have received the notice of seller or seller's agent at Alang that the vessel is ready, delivery is also. Now it has changed in third amendment of letter of credit and point number 7 was deleted and new point number 9 was added and the same was opening by confirming the buyers have received the notice of readiness from the seller and seller's agent at Alang that the vessel is ready to be delivered physically to buyers. The crucial change is that the original letter of credit, the vessel has been physically delivered to buyers and subsequently the change is vessel is ready to be delivered. So it's something that learned judge notices. In pursuance of the changes in letter of credit on so-and-so, the defendant number 3 has sent certain documents such as bill of sale and certain commercial invoices, letter of undertaking, credit certificates, etc. Therefore, 1/6/2021, plaintiff wrote a letter to defendant number 2 regarding accepting the documents of vessel so-and-so. It is mentioned that we are accepting the documents, the same will accept, etc. This we have read. Now, please see how this document is. Now, on the basis of the letter at March 3/13, which is page 32 of my compilation, written by the plaintiffs to its bank, defendant number 2. Defendant number 2 has sent a swift message on 3/6/2021 to defendant number 3 and narrated that document was $$ so-and-so under letter of credit reference has been accepted to be paid on 19/11/21. We will remit the negotiated amount as per your instructions on due date. This document is produced at 3/14. On the strength of such swift message, the defendant number 3 discounted the letter of credit in favor of the defendant number 1, but the plaintiffs and defendant were kept in dark about it. When, as per amended expected date of delivery, the plaintiff did not get physical delivery, therefore the plaintiffs have communicated. Then the communication starts. So this is now I can straight away go to page 123, para 25. Then there is a narrative about para 25 at page 123. Now looking to mark 3/34, which is an important document wherein first time defendant number 3 declared that they have financed the deal upon acceptance dated 3/6/2021 and do not agree on the cancellation of this entire letter of credit. Now question is, why the defendant number 3 kept silence till 22nd of October 2021? It is more than 4 months after the discounting of letter of credit. This fact raised serious doubts towards the conduct of defendant number 3 because the defendant 1 and 2 entered into correspondence with defendant number 3 since long for cancellation of the letter of credit, but the defendant number 3 did not reply and very first time on 22nd October 2021 declared that they have financed the deal on acceptance of document dated 3/6/2021. Look, pausing here for a moment, this entire issue about post termination, we are talking about a period of 2 months only. Sometime in September, there is a termination between the two principal parties, and they approach us saying that LC is to be terminated. Now, as a banker, I am bound to put it across to my customer that this LC is to be cancelled. So, unless I get a clearance from him and the money back from him, I cannot cancel the letter of credit. So, obviously, some time goes in that. Unfortunately, this is not documented. So subsequently, when I realized that the money is not going to come from Capital Corp, and I am not in a position to cancel the letter of credit, I say that there is nothing I can do about it. Now, this entire noise which is being made about 2 months period, this is just an argument of desperation. How does it matter? At the end of the day, the whole point of the matter is that was a proper procedure followed or not? Whether there is a delay in telling you, etc., these are all irrelevant aspects, which also have appealed in my respectful submission, wrongly appealed to the learned judge. Now, please, reading further. Looking to mark 3/34, it appears that defendant number 3 has financed the deal only upon relying acceptance of document of 3/6/2021 and did not take care to verify whether vessel was physically delivered or not. Very, very crucial. If 3/6/2021, the issuing bank tells me that please go ahead, an amount will be paid on the due date, I'm getting the green signal from the issuing bank, can I still say that I'll not pay? And the learned judge says that still I should have taken a reasonable care to find out whether the vessel is actually delivered or not. Now, where does the law ever impose such an obligation upon a banker? The entire banking world will come to a grinding halt if these are the precautions to be taken. A banker is not supposed to look into anything. That is the law. Because it was a prime condition of original letter of credit and subsequent letter of credit, we physically delivered the vessel. Then after the plaintiff wrote a letter on 28/10/2021 to defendant number 1 and asked him, have he really applied to cancel the letter of credit? And if so, how could you be so if you have received payment of funds? Then after also wrote a letter, etc. Sir, I can skip that. Then come to page 125 bottom, last line. I'm only highlighting the findings because the discussion I'm avoiding. My learned friends, if they feel I have left out anything, they can certainly read. Page 125 bottom. Thus, looking to all the documents, it clearly appears that it was fraud committed by defendant number 1 with plaintiff, and defendant number 3 has financed defendant number 1 on 30th June 2021 merely on the strength of acceptance of documents and without confirming whether vessel was physically delivered or not. Once again, because the learned judge says this. Where is the requirement? And without confirming the terms and conditions of the letter of credit and without confirming the notice of readiness issued or not. So once again, the learned judge. So when faced with this 3 documents, if I can say, 1st June, 3rd June, and subsequent SWIFT message. So 1st June, 2 documents issued by Hussain Ispat to Canara Bank and Canara Bank SWIFT message. When you are confronted facing these 3 documents, you come out with such an argument, which the learned judge accepts, saying that in spite of those, please see this, that in spite of this, those 3 documents, still there is a burden upon me, cast upon me to find out what, whether the vessel is delivered or not. Now, delivery of the vessel, again, let's assume everything against me. Where is it a requirement that the vessel had to be physically delivered? So the learned judge relies upon something which is now no longer part of either the agreement between the parties or the letter of credit. There is no requirement for physical delivery. Only thing is notice of readiness. Now, after these 3 documents, can any law ever cast an obligation upon a banker who is negotiating a letter of credit to find out whether the notice of readiness has actually been given or not? If there is a discrepancy, point out. If you don't point out, waiver applies. So where is the question of casting this heavy obligation upon me? How do I find out? And how tomorrow, if I don't pay to Capital Corp, they are going to sue me that you wrongly withheld under the letter of credit. Look at the UCP. If they are not objecting, who are you to object? Neither the issuer is objecting, neither is the issuing bank is objecting. So who are you to say that no, but because notice of readiness is not given, I will not reduce the money to you? Would such a stand of my client ever be countenanced? That is the test. Can I today or at that point in time, could I have said that because notice of readiness is not given, sir, I am not in a position to release the money? The bank will, the beneficiary will sue me. No, this is, then page 127. Somewhere in the middle. On the basis of this, the plaintiff wrote a letter of 1/6/2021, mark 3/13 regarding accepting the documents of vessel, and on the strength of mark 3/13, a swift message sent by Canara Bank to DBS Bank, which is produced at 3/14. And when it is mentioned that documents have been accepted, but in this message, notice of readiness and physical delivery of vessel is not mentioned. And on the strength of this message, the defendant number 3 discounted the letter of credit. Then on the next page, page 128, again, last 6 or 7 lines. Page 128, this last 6 lines. Here in this case, it clearly admitted position that whenever, whatever mistakes are committed is by defendant number 2. Please note this, sir. Very important. Admitted position that whatever mistakes are committed is by defendant number 2 and defendant number 3 because defendant number 2 has conveyed the message in other way. Looking to mark 27/3, it is regarding letter of acceptance of documents, but it is printed form and blanks are filled by the bank. Sir, page 33, the learned judge records the finding without there being it being anybody's case. Because the plaintiff does not produce that 33 on record. He clearly suppresses it. It is not plaintiff's case that the blanks are not filled by me, but they are filled by the bank. It is not plaintiff's case that I have not signed without, or I have signed without knowing. Without there being any pleading, the learned judge finds that the blanks are filled by the bank. Date is also filled by the bank. How does the learned judge come to this conclusion? Date is also filled by the bank. Wherein it is also stated that this acceptance letter is given by us in continuation of FLC agreement cum application. Therefore, the terms and conditions of the first LC is to be fulfilled. It appears that the signature of the plaintiffs were obtained. Now let anybody show anywhere with reference to this document that it is the case of the plaintiff that this particular document, page 33 of my compilation, which is the communication issued by the plaintiff to Canara Bank, was not executed by them, not signed by them. They were forcibly asked to sign. The signature was obtained. What do we mean by obtained? Was a gun pointed at you? How was it obtained? The learned judge simply says that so an inconvenient document is completely brushed aside by recording such findings that it was obtained. So therefore, it has no value in law. The notice of readiness was not complied. There is nothing mentioned in the letter written by the plaintiff for unconditional acceptance of documents. The acceptance of documents were subject to conditions. The conditions will remain same in mark 3/10. Looking to 3/11, it clearly means that documents are to be required and field 47B point number 7, actual delivery is to be required. Condition number 9 is about to timing of presentation of documents, meaning thereby that if plaintiff got physical delivery of vessel on 15/6/21, then document is to be presented, but the defendant number 2 did not comply it and presented the document on 1/6/2021, and for that the plaintiff cannot be prima facie held liable. The defendant number 3 is doing business of banking. He must be bound by his condition. It was also duty of defendant number 3. Now, where do we get this? That 15/6/2021 negotiation of the letter of credit could have happened anytime upon acceptance or availability of the documents. So this is again on the face of it an erroneous finding that this presentation on 1/6, it's not even the plaintiff's case. It is not even the plaintiff's case that presentation on 1/6/2021 was premature. Nobody's case. He has presented the document before him. They have to verify that he issued a notice of readiness or presented or not. The defendant number 3 is also to verify the documents presented by the defendant number 1. And now the defendant number 2 presented these documents by breach of condition number 8 and 9. Defendant number 2 presented this document by breach of condition 8 and 9? I do not, I honestly fail to understand. Because defendant number 2 has not presented the document. It is the defendant number 1 who has presented the document to me. I have presented to defendant number 2, and defendant number 2 has presented it to the plaintiff. Then your honor will find at page 131 some more findings. Fourth line from the top. The defendant number 3 presented the documents without complying condition number 8 and 9 of letter of credit and did not take due and reasonable care. Now, this is where again an error comes in. I am not required to present that. There is no, as far as field 40, the other field 47 is concerned, in conditions 8 and 9, they are part of other conditions. Additional requirements. Then your honor will find further findings at page number 133. Fourth line. Therefore, also he has to wait till physical delivery of the vessel. Much before that, he has discounted the letter of credit on 3rd June 2021. Sir, again, with the greatest respect, physical delivery is done away with completely. Still, the learned judge records such a finding without there being such case. It is very much clear that letter of credit is not only for the production of the seller, but at that same time, it is also for, it should be protection of the buyer also. Now, Milos, straight away, then your honor may come. For page 131, Milos, somewhere in the middle. 131, somewhere in the middle, by not complying. Moreover, a physical, that's 7th or 8th line. Moreover, a physical delivery of vessel was a condition over and above condition 8 and 9. And it is also inbuilt condition in the letter of defendant number 3, dated 28/5/2021, regarding total local delivery of vessel. By not complying condition 8 and 9, defendant number 3 took business of risk. And when it is business of risk, it cannot pass on the plaintiff. The prudent man must inquire about the physical delivery of the vessel and notice of readiness, which were prime condition. But the defendant did not inquire. Where, sir, this is, it becomes, if this kind of view, with the greatest respect to the learned judge, is upheld, the entire banking world will be in disarray. Completely in disarray. But this is not even the case of the plaintiff. That is the worst part of it. This is not even the case of the plaintiff. Physical delivery is not, but they have said that because we did not get the physical delivery, we found that the defendant number 1 is not in a position. We at that stage realized that some egregious fraud has been perpetrated by defendant number 1 and his agents. But it is not their case. Their case simply could have been that physical delivery was a condition precedent for presentation and encashment or negotiation of a letter of credit. There is no such case. And the learned judge still records such a finding. Then your honor may see at now at page 137. That is where the UCP, which I so heavily rely upon, the learned judge reproduces 137 para 30. Then please see how it is dealt with at page 138. Thus, it is very much clear that issuing bank has to inform that presentation does not comply. Here in this case, issuing bank, Canara Bank, is not informed about the non-application of presentation. Therefore, principle of waiver applied in this case. I do not agree with arguments of learned advocate for defendant number 3, because defendant number 3 was duty bound and has to act upon the original terms and conditions of the letter of credit. No doubt, letter of credit is a contract between bank to bank and not parties. Therefore, it is not concerned with the parties. And before discounting the letter of credit, defendant number could have been vigilant. It was also duty of defendant number 3 to verify the documents submitted by defendant number 1. Defendant number has not verified that physical delivery of the vessel was not handed over or not, and also not verified that the notice of readiness was given or not. Without verifying this document, defendant number 3 discounted the letter of credit. So this condition or conditions precedent, and as per Chalmers on bills of exchange, exact compliance with the terms and conditions of credit is sine qua non, meaning thereby that exact compliance with the terms of the credit is to be followed by defendant number 3 before discounting letter of credit. Here in this case, it was not followed and breached by the defendant number 3. And when the breach committed by the defendant number 3 and defendant number 2, therefore, for the plaintiff may not be penalized. Looking to the swift message of 1st June, the physical delivery of vessel was expected on 15 June. Till waiting that day, the defendant number 1 premature discount the letter of credit on 3/6/2021. So what the learned judge says is that when the date of delivery is extended, original 21st May to 15th June, the delivery could not have been before 15th June. It could not have been on 1st June. So when the date of delivery itself is extended, how did you? Therefore, the encashment is premature. This is not even the case of the plaintiff. It is absurd on the face of it to even suggest that. After discounting the letter of credit, the defendant did not inform even the defendant and plaintiff. Now, I will just offer my comments to this finding. Now, the UCP, when you apply the principle of waiver, there is obviously a mandatory requirement. There are times when there are mandatory requirements in law, but they are meant for the benefit of a person. So such mandatory requirements in law, the courts have taken the view, can be waived. So if, let's say, a statute obliges an authority to give a notice, and I am not given a notice, I can still appear before the authority and say that this is my case. I can't be then heard to say that no notice was given. So, Milord, the point here is that what the UCP incorporates is a principle of waiver which has to apply in all situations. Now, learned judge, with the greatest respect, says that because these are conditions precedent, you not acted in accordance with the conditions precedent. So, because you have not acted in accordance with conditions precedent, you have breached, and therefore you should be held liable. But then every situation which calls for application of the doctrine of waiver, the principle of waiver, will always involve breach of a mandatory requirement. So if there is a mandatory requirement and if it is breached, you cannot say that the principle of waiver will not apply. Principle of waiver will equally apply to conditions precedent and mandatory requirements. They have to apply. That is the whole principle that is about. So if there is a requirement, so here, when you talk about this UCP requirements, these requirements are basically for the protection of the issuing bank and the issuer. So you will not permit negotiation unless you have received confirmation from them. If you have received a notice of discrepancy, you will not negotiate. So it is a requirement for their benefit. So if they have accepted, they can't be heard to say that, but principle of waiver will not apply because we are going around in circles. Therefore, because this is also where there is a serious error when the learned judge says completely ignores the Article 16. Now, paragraph 141 is where the Supreme Court judgment is dealt with. Page 141, para 31. Here in this case, it clearly appears on the face of the record that defendant number 2 has obtained signature of plaintiff in the form of acceptance of the documents, and the documents are in propounded form. Now, how does, with the greatest, no pleading of this to this effect, no pleading worth the name. The defendant number 2 and defendant number 3 have not verified the documents. Moreover, defendant number 3 has not awaited for physical delivery of vessel on 15/6 and discounted the letter of credit on 3rd June. Moreover, defendant number 3 has not informed the defendant number 2 of plaintiff, etc. These are all reiteration, but then page 142 bottom. In the middle, Supreme Court in Federal Bank is noted. Then see how it is dealt with. Looking to the judgment of the Honorable Supreme Court and the facts of the present case, it appears that in the judgment, the applicable rules of UCP were of 1983 revision, which are not bearing in this case because in the present case, these applicable rules are UCP 600. In para 6(7), clause 9 of the judgment, it was one of the documents to be produced by seller for payment should be copies of delivery challenge cum invoices issued by just one steel rolling. In para 10, it is held that for the purpose of the main point arising in the case, it is important to note clause 9 of the letter of credit. Principle of waiver of credit and much more emphasis in clause 9, para 7 and 9. Then after para 12(8) is clearly stated, except for payment, etc. Thus, Vice President has accepted the documents for payment of maturity. Therefore, principle of waiver was applied to him and he cannot resign from it. And when the Vice President himself has accepted the payment of maturity. On the basis of it, letter of credit was remitted. When in the present case, no such acceptance was made by the present plaintiff. How do we ignore 1st June 2021 and say this? On the contrary, conditions 8 and 9 of physical delivery of vessel and issuance of notice of readiness was not fulfilled. Therefore, it cannot be said that it was an acceptance in accordance with rules. Thus, the facts of the Honorable Supreme Court is quite different from the facts, etc. But then other judgments of the Supreme Court, and then straight away Your Honor may come to the operative portion. Sorry? That's all right. Page 150, para 36, Your Honor may kindly see, where the learned judge says that this is a conditional letter of credit. Page 150, paragraph 36. Keeping in mind the aforesaid principles and having considered the case of the plaintiff, it is undisputed fact that the letter of credit was not an unconditional. There was a condition of physical delivery of vessel and notice of readiness is to be given by the seller. Both the conditions are not fulfilled. This is the basis. It's a reiteration of the same finding again and again, so I'm not offering my comment. But having said that, please see the injunction which is granted at page 54. The ad interim relief granted earlier be made absolute till the final disposal of the suit. So injunction in terms of what is paid for by the plaintiff has been granted. Sir, Federal Bank judgment of the Honorable Supreme Court has been discarded, if I can use that word, by the learned single judge, by recording only one line finding that there is no such acceptance in the present case. Because Federal Bank, the officer of that company, accepted the concerned invoice, etc., and Supreme Court applied the principle of waiver. Here also I am saying that 1st June, the 3 documents which I refer to are acceptances. Now, how do we say that it is not an acceptance? No, this one line assertion by the learned trial court to completely ignore and discard the Supreme Court judgment, which according to me is absolutely on identical facts, by simply saying that there is no such. So, please see how this has all gone about. Now, and at the cost of repetition, I am saying it. These 2 documents are clearly staring at the defendants and the plaintiff. The 1st June documents and the printed format and the swift message from Canara Bank. So, to grant relief to the plaintiff, one has to come out of those documents. Now, of the 3 documents, one is not even produced by the plaintiff. There is no pleading to support anything concerning that document. Still, the learned judge says that these are documents which are obtained, filled in, the blanks are filled in, the date is filled in by the bank, etc. The bank will obviously answer. The bank today is in a mood to support the plaintiff. So I do not know whether the bank is going to come out with a true case or not. But if we see the pleadings of the bank, the return statement, etc., they are completely opposing the suit. So we'll see in arguments what exactly stand they take up. But my submission, therefore, is that the learned trial judge has clearly heard. There are some other judgments which I will show, because if I can continue after recess or 3 o'clock. 3 o'clock.
Honorable High Court has extended the stay against Exhibit 25 till today. First, on the first hearing of this appeal. Extension and I'm going to move that.
As on today, the stays in operation as on today.
High Court a order given. However, while issuing notice, the court stayed the order below Exhibit 25, and which is continued till today, is extended till the first date of hearing before the appellate court on an appeal that may be filed by the petitioner. So today is the first day of appeal for hearing. So it may be extended. Okay. On extension,
Okay, show the 16 judgment. Just 3 judgments now, and I will. ત્રણે આપી દો ને. 2 આપી દો. UPC to. Yeah. There's some law on letter of credits, credit and bank guarantee. Tarapur and Company, 69 judgment of the Honorable Supreme Court. But this was at a stage when there was a 1962 UCP which was prevalent. In para 2. Your Honor will find there is a reference to 1962 UCP. Yes. Then the articles of the UCP which were then prevalent. In para 2, last line. The agreement entered into between Bank of India and Russian firm under the letter of credit was subject to the uniform customs and practice for documentary credits. International Chamber of Commerce, Article 3 of the brochure says that, and then Article 3, 8, etc. Then 4, paragraph 4, the only other article in that brochure which is relevant for our purpose is Article 9. Then, sir, having noticed this articles and the facts, I will show only 3 paragraphs, para 12, 13, and then 18 on the law with the Supreme Court lays down, because these were early days, 1969, but still see what is the, and this is good law today, consistently followed. Para 12. The scope of an irrevocable letter of credit is explained thus in Halsbury's Laws of England. It is often made a condition of a mercantile contract that the buyer shall pay for the goods by means of a confirmed credit, and it is then the duty of the buyer to procure his bank, known as the issuing or originating bank, to issue an irrevocable credit in favor of the seller, by which the bank undertakes to the seller, either directly or through another bank in the seller's country, known as the correspondent or negotiating bank, to accept drafts drawn upon it for the price of the goods against tender by the seller of the shipping documents. The contractual relationship between the issuing bank and the buyer is defined by the terms of the agreement between them, under which the letter opening the credit is issued, and as between the seller and the bank, the issue of the credit duly notified by the seller creates a new contractual nexus and renders the bank directly liable to the seller to pay the purchase price or to accept the bill of exchange upon tender of the documents. The contract thus created between the seller and the bank is separate from, although ancillary to, the original contract between the buyer and the seller by the reason of bank's undertaking to the seller, which is absolute. Thus, the bank is not entitled to rely upon the terms of the contract between the buyer and the seller, which might permit the buyer to reject the goods and refuse payment thereof. And conversely, the buyer is not entitled to an injunction restraining the seller from dealing with the letter of credit if the goods are defective. Chalmers on Bills of Exchange explains the legal position in these words. The modern commercial credit serves to interpose between a buyer and seller a third person of unquestioned solvency, almost invariably a banker of international repute. The banker, on the instructions of the buyer, issues the letter of credit and thereby undertakes to act as paymaster upon the seller, performing the conditions set out in it. A letter of credit may be in any one of a number of specified forms and contains the undertaking of the banker to honor all bills of exchange drawn thereunder. It can hardly be overemphasized that the banker is not bound or entitled to honor such bills of exchange unless they and such accompanying documents as may be required thereunder are in exact compliance with the terms of the credit. Such documents must be scrutinized with meticulous care. The maximum of minimus lex cannot be invoked where payment is made by letter of credit. If the seller has complied with the terms of the letter of credit, however, there is an absolute obligation upon the banker to pay irrespective of any disputes there may be between the buyer and the seller as to whether the goods are up to contract or not. Then Your Honor may see paragraph 18 at the bottom. A case somewhat similar to the one before us came up for consideration before the Queen's Bench Division in so-and-so. Therein the plaintiffs, Jordanian firm, contracted to purchase from the defendants a British firm a large quantity of reinforced steel rods to be delivered in 2 installments. Payment was to be effected by opening in favor of the defendants of 2 confirmed letters of credit with the Midland Bank in London, 1 respect of each installment. The letters of credit were duly opened and the first was realized, and the defendants on the delivery of the first installment, the plaintiffs complained that the installment was defective and sought an injunction to bar the defendants from realizing the second letter of credit. So-and-so the trial judge refused the application. In appeal. Jenkins, Sellers and Pierce LJJ confirmed the decision of the trial judge. In the course of his judgment, Jenkins LJ, who spoke for the court, observed thus: we have been referred to a number of authorities as it seems to be plain enough for the opening of a confirmed letter of credit constitutes a bargain between the banker and the vendor of the goods, which imposes upon the banker an absolute obligation to pay, irrespective of any dispute there may be between the parties as to whether the goods are up to contract or not. An elaborate commercial system has been built up on the footing that bankers' confirmed credits are of that character, and thus, in my judgment, it would be wrong for this court in the present case to interfere that established practice. There is this to be remembered too. A vendor of goods selling against a confirmed letter of credit is selling under the assurance that nothing will prevent him from receiving the price. This is of no mean advantage when goods manufactured in one country are being sold in another. It is furthermore to be observed that vendors are often reselling goods brought from third parties. When they are doing that, and then they are being paid by the confirmed letter of credit, their practice is, and I think it was followed by the defendant in this case, to finance the payments necessary to be made to their suppliers against the letter of credit. That system of finance of these operations, as I see, would break down completely if a dispute as between the vendor and the purchaser was to have effect of freezing, if I may use the expression, the sum in respect of which the letter of credit was opened. So because I am relying on this judgment to support my contention that this dispute between Capital Corp and the present plaintiff, where the plaintiff elaborately in the plain makes allegations of fraud against Capital Corp, are not relevant for our purposes. As far as the letter of credit is concerned, it is governed by its own terms, and the Supreme Court says, approves the law as laid down by English courts, that if the presentation is proper with the documents required, then you have to pay. There is an obligation to pay. So 2 things are required. One is the one who's presenting must present the relevant documents, and once there is proper presentation, then the amount has to be paid. So that is the purport for showing this judgment. There's one more judgment, which is 2016 judgment of the Supreme Court, where the law on bank guarantee is discussed. A paragraph 12 of that judgment. This arises out of a matter decided by the Gujarat High Court, where a stay against invocation of the bank guarantee was granted in a matter where the GMB, which is the appellant, was not in a position to give a particular plot. So though it was not in a position to act in terms of the contract which it had entered into, it still wanted to invoke the bank guarantee. The respondent challenged that. The Gujarat High Court protected against invocation. The Supreme Court says nothing doing. And please see para 12. An injunction against the invocation of an absolute and an unconditional bank guarantee cannot be granted except in situations of egregious fraud or irreparable injury to one of the parties concerned. This position is also no more res integra in Himadri Chemicals at para 14, Supreme Court. From the discussion made here and above relating to the principles for grant or refusal or grant of injunction to restrain enforcement of a bank guarantee or a letter of credit, we find that following principles should be noted in the matter of injunction to restrain the encashment of a bank guarantee or a letter of credit. While dealing with an application for injunction in the course of a commercial dealing, and when an unconditional bank guarantee or letter of credit is given or accepted, the beneficiary is entitled to realize such a bank guarantee or a letter of credit in terms thereof, irrespective of any pending dispute relating to the terms of the contract. 2. The bank giving such guarantee is bound to honor it as per its terms, irrespective of any dispute raised by its customer. The courts should be slow in granting an order of injunction to restrain the realization of a bank guarantee or a letter of credit. Since a bank guarantee or a letter of credit is an independent and a separate contract and is absolute in nature, the existence of any dispute between the parties to the contract is not a ground for issuing an order of injunction to restrain enforcement of bank guarantees or letters of credit. Fraud of an egregious nature, which would vitiate the very foundation of such a bank guarantee or letter of credit, and the beneficiary seeks to take advantage of the situation. And 6, allowing encashment of an unconditional bank guarantee or letter of credit would result in irreparable harm or injustice to one of the parties concerned. So these are the principles which are to be applied. Now, if we take each one of, as far as I already said, that the dispute inter se between the vendor and the purchaser is not relevant for our purposes. But the Supreme Court talks about an unconditional bank guarantee or unconditional letter of credit. So because an unconditional bank guarantee or an unconditional letter of credit is a document by which the bank undertakes to pay moment there is proper presentation in terms of that document. So even if a bank guarantee is to be invoked, if there is a certain manner of invocation provided for in the guarantee itself, then the invocation has to be in that manner. Similarly, if a letter of credit is to be encashed, then if it requires certain documents to be produced, it has to be in that manner. So that is what the court means. So once the presentation is done in a proper manner, then the payment has to follow as a matter of course, and courts would normally not injunct. Now, as far as our case is concerned, therefore, if we take out the main dispute out of the equation about not having received vessel, no the fraud which was thought of or conceived by the vendor, etc., then the only question which remains is that was the presentation proper? To which, because my answer is, and I have already made elaborate submissions, that so long as I have the documents required to be presented, if they are presented, then the presentation is in compliance. That is my submission. What is the effect of the requirement of conditions 8 and 9, which talk about there being a notice of readiness, etc. Non-compliance with that will not vitiate my presentation. The presentation by the presenter and my presentation to the Canara Bank will always be treated as a compliant presentation. This moment I present the documents which are required to be produced. So that is my first submission. Therefore, the presentation is compliant. Second is their entire argument that a notice of readiness is not given. Now, if we see the agreements, the amendments to the agreements as well as the amendments to the letter of credit, it emerges from the record very clearly that the time for delivering the vessel has been extended from time to time. So there was no scope for there being a notice of readiness. for that matter, or a delivery of the vessel. Therefore, the trial court, when it continuously talks about not having examined whether there is notice of readiness or not, but on one hand, when you are seeking extension of time, because the LC is also amended to incorporate that. So we have documents where there is extension of time sought for delivery of the vessel. Obviously, there would not be a notice of readiness. So there was no such requirement for the purpose of negotiation. That is what I'm trying to show. So if we take the overview, see how the entire contract has progressed, performance has progressed over a period of time, there was no scope for either delivery or notice of readiness. That is the second. And the third argument, which is the most important argument, which I believe should clean the issue, is that as a banker, and this is something which applies to all bankers, in a given case, Canara Bank could be in my place. Sir, moment we receive documents, our obligation is to complete the entire process within a period of 4 or 5 days. The Supreme Court says that you have to see on the face of the document whether there is discrepancy or not. So it doesn't call for detailed scrutiny. When you talk about on the face, it doesn't call for a detailed inquiry. So my obligation would be to forward the document to Canara Bank. If I have forwarded the document to Canara Bank, and if I have acted on the basis of the clearance given by the Canara Bank, the matter should rest there. I don't need to go any further. If Canara Bank has told me on 3rd of June that you pay and I'll pay you on the due date, the matter ends there. I must get my money from the Canara Bank. That is the next subject. Going further, it doesn't stop at Canara Bank. The documents which I had forwarded to Canara Bank were in turn forwarded to Hussain Ispat, and they have also given their confirmation. Now, their entire argument that please read this document to mean this, or our signature was taken on a blank paper, things have been blanks have been filled, the signature was obtained. These are not matters which will be a basis for asking or directing or injuncting Canara Bank not to pay, which is legitimately due to. Because the moment your lordships permit this, then every commercial dispute, there will be an issue like this. And the entire banking world, in my respectful submission, there would be a complete chaos. Because every payment that has, any banker who, sir, the rule is that I cannot get into anything. I have to pay moment there is a letter of credit in document. So, my submission. So, as far as prima facie case is concerned, I would very respectfully submit that the plaintiffs have no prima facie case, no case, let apart prima facie case. In any case, there is no prima facie case in their favor. Now, that brings me to the question of balance of convenience, because eventually this is a matter of injunction. So today, it is nobody's case that I am not good for the money which I will get if an injunction is not issued. So if the Canara Bank is permitted to pay to me, what is the prejudice? And that is where the Supreme Court judgments come in about irreparable injury. So neither has the plaintiff pleaded any such injury, nor is there any such injury possible. Eventually, if the plaintiff succeeds in the suit, then there will be a decree directing me to pay the money back, if at all it is found what they are saying is correct. So at the end of the trial, if eventually I lose, then the plaintiffs are not remediless. And therefore, in a bank guarantee or a letter of credit matter, unless your honor finds that if this money leaves the hands of defendant number 2 and travels into my hands, there are chances that the plaintiff will not get back that amount. There is no such case. It is nobody's case. Therefore, my submission is that on balance of convenience, the plaintiffs have no case. Assuming there is some tribal issue based on what the other side is contending, assuming for the sake of argument. Still, where is the balance of convenience in terms of the Supreme Court judgments, where the Supreme Court says that unless a fraud underlying the bank guarantee, so if the guarantee is extracted on the basis of some fraud, and if it is issued and is the issuance of the bank guarantee itself is vitiated by fraud, independent of the parent contract, the ancillary contract, which is a separate agreement between the bankers and is vitiated by fraud, you can't grant. That is what the Supreme Court says, number one. Number two, Supreme Court says that irreparable injury will have to be established. That is as far as the balance of convenience is concerned. Therefore, my submission is that neither is there a fraud pleaded, nor is there balance, and prima facie, therefore, this injunction is required to be vacated by quashing and setting aside the trial court. Obliged.
You are called respondent.
I am called respondent number 1.
Respond number 1.
The original plaintiff.
That's it. फोन ले या माइक क्या मुकवाना तुम्हारा Sir, not accustomed to speak on the mic. Kindly tell me if it is too much.
I am telling you in advance. You have already.
I was only addressing the court. No, but thank you. So, yes, there is some manufacturing defect. We're not sorry. Sir, the appellate powers over an interlocutory injunction under Order 39 are in a way restricted. And those restrictions I will show at the last, so that I don't want to start with any attempt to suggest that Your Honor is not supposed to look into the facts of the case. Certainly, we have to show all the facts to Your Honor. But the appellate powers of interference in the exercise of discretion are restricted. And right from Wander versus Antox 1990 till 2023, the latest judgment of the Supreme Court, they repeatedly say that an exercise of discretion under Order 39 may be interfered with only if Your Honor finds that the trial court's exercise of discretion is perverse. As long as Your Honor finds that this is not perverse, then interference is not called for merely because perhaps as a first instance judge, Your Honor might have been inclined to take another view. So it is within that limitation, I request Your Honor to have a look at this entire exercise of hearing the appeal. Sir, there are 3 exceptions to the rule that ordinarily no injunction would be granted against the encashment of the letter of credit. First is the fraud. Second is the special equity or irretrievable prejudice. And the third is, which is equally important but frequently missed, and I would say underemphasized, is that the bank guarantee must be honored only if the invocation is in terms of the bank guarantee. So the attempt to invoke and encash the bank guarantee or a letter of credit in this case, our case is that not only there is a fraud, but a fraud of an egregious nature, a fraud which runs right from the inception, but even the encashment attempted is not in terms of the bank guarantee. The conditions of the letter of credit are also not fulfilled. Therefore, my effort is to show to Your Honor 2 things. One is, kindly see the terms of the letter of credit and the conduct of the defendants or the appellant. And please see whether this is in compliance. The second is to show the fraud. And lastly, I will deal with special equity, because special equity is in a way linked to the aspect of balance of convenience. So, sir, kindly see the factual aspect very briefly. The memorandum of agreement was made on 21st of April 21. Your Honor will find it at mark 3/3 of the trial court's record. And the three things which are required to be noted in this first agreement of 21st April 21. The purchase price was US dollars 31,58,540. So 3.1 million approximately. The second aspect was that the original memorandum of agreement provided that the LC would be established for 2 million, 20 lakh dollars. Yes, I pass High Court paper book. I can refer to High Court paper book also if Your Honor has the original record. I would go by the trial court's record. Your Honor may kindly see that the price 31.58.540. The LC was to be established through Punjab National Bank for a sum of US dollars 2 million. And the balance amount was to be paid by telegraphic transfer. So initially they contemplated that out of the total price of 31 lakhs, we'll pay 20 lakhs through LC and 11 lakhs by telegraphic transfer. Now, within 2 days, on 23rd April 21, there was the first amendment to the agreement. And there were two changes made. One was that from Punjab National Bank, it came to be Canara Bank. Yes. That also is a part of 3/3, in fact, in the trial court record. Addendum 1. Lordships. So instead of PNB, it became Canara Bank, and the LC amount was increased from 20 lakhs to 24,58,540, and the telegraphic transfer was reduced to 7 lakhs. Yes. So this was the first amendment of the agreement. Now the matter does not stop here. There is a second amendment to the MOA on 13th of May 21. Yes. By the third amendment, now it is decided that entire price 31,58,540 would be paid by LC and no telegraphic transfer. Everything to be paid by the letter of credit. So from 21st April to 13th May, Your Honor finds that the LC value increases from 20 lakhs to the entire price, and the telegraphic transfer from 11 lakhs comes to 0. So this is the second amendment to the agreement on 13th May. The remaining amendments I'll come to little later, because they all pertain to shifting and postponing the dates of delivery of the vessel. But so far as the payment terms are concerned, they became frozen by the time second amendment was made on 13th May. That the entire amount would be paid by a letter of credit. Now, Your Honor will have to see, in connection with this, the amendments in the LC. The LC was in the first place issued on 26th April 21 at mark 3/4. Your Honor finds LC at 3/4. Yes. The date is 26th of April 21. Then, sir, there was first amendment to the LC made on 4th of May 21. From 26th April to 4th May. First amendment to the LC. Your Honor may kindly see that first amendment for a moment. If your Honor will see that amendment 1, kindly see the second page. (46B) documents required, that column. Point number 4, now to be read as a letter of undertaking from sellers that they will submit to the buyers copy of certificate from present port of registry stating that the time of delivery, the vessel is free of encumbrances. This was 46B, point number 4. It was one of the documents to be presented that the vessel is free from encumbrances, and a certificate to that effect from the present port of registry has to be issued. Kindly see the next point. Point number 7, now to be read as a tested telex or swift advice from the opening bank confirming that the buyers have received the notice of readiness from the seller's agent, seller or seller's agent at Alang, that the vessel is ready to be delivered physically to buyers. Now, what is that amendment made? To appreciate that, your Honor will have to kindly go to the original LC as issued on 26th April. And your Honor will find in the 46B column, document number 7. Your Honor will find it is the third internal page of the LC. On the left-hand side, your Honor will find 46 capital A, documents required. Kindly see the last. A tested telex or swift advice from opening bank confirming that the buyers have received the notice of readiness from the seller or seller's agent at Alang, that the vessel has been physically delivered to the buyers. So when the LC was issued on 26th April, the condition was, and that is the document required, which must be presented before money can be claimed under the letter of credit, that the vessel has been physically delivered to the buyers. This was amended on the 4th of May by this condition, that not actually delivered, but the notice of readiness from the seller or seller's agent at Alang that the vessel is ready to be delivered physically to buyers. So the first amendment to the LC made these changes. Now kindly come back to that first amendment. I want your Honor to look at 72Z, the last item.
Yes.
All other terms and conditions to remain the same. So except what is amended, all other terms and conditions of the original LC, which was issued on 26th April 21, was to remain the same. Now, sir, this LC necessarily had to undergo a further amendment, because from 20 to 24 lakhs and 24 lakhs to 31 lakhs, those amendments, Your Honor will find second amendment to the LC is made on 18th of May 21, which is another 2 weeks after 4th May. Your Honor will find it at 3/9. This second amendment to the LC is only 1-page document, amendment 2. Your Honor may kindly see the last 72Z, all other terms and conditions to remain the same. One more amendment came into the LC on 24th of May. So Your Honor finds that from 26th April to 14th May to 18th May to 24th of May, this letter of credit underwent 3 amendments. This was the last amendment, 24th of May, and that is important. Kindly see, Your Honor will find it at 3/11, the third amendment. The important amendment is, Your Honor may kindly see in that field description 46 capital B, document required. It says delete point number 7. So if Your Honor goes to that amendment by which point number 7 was changed from actually delivered to be ready to be delivered, that underwent a further change. And they deleted point number 7. Now, what is the consequence of this deletion? The consequence is that the various documents which are required to be presented included one document at item number 7 of this field, originally saying vessel actually delivered, by amendment saying vessel ready for delivery, but that document has to be presented as a part of the presentation of documents under 46B. By this last amendment, they said that delete this condition number 7. So we will not require this document, but we will put it as an additional condition in 47 capital B. And that additional condition, Your Honor may kindly see. Document to be presented after the receipt of an authenticated SWIFT message as under. So instead of presenting this as a document under item number 7, the additional condition now provided a condition precedent as to which point of time these documents can be presented. And this is the most critical aspect of this entire matter. It says document to be presented after the receipt of an authenticated SWIFT message as under. Now, what should be that SWIFT message? A tested telex or SWIFT advice from the opening bank. Opening bank is Canara Bank, confirming that the buyers have received the notice of readiness from the seller or seller's agent at Alang that the vessel is ready to be delivered physically to buyers. Sir, the impact of this condition is that there has to be in the first place a notice of readiness from the seller or seller's agent received by the buyer to the effect that the vessel is ready to be delivered physically to buyers, and Canara Bank must confirm that the buyers have received such notice. Only after Canara Bank confirms this, the documents can be presented, not before. Document to be presented after receipt of an authenticated SWIFT message as under. A tested telex or SWIFT advice from the opening bank confirming that the buyers have received the notice of readiness from the seller or seller's agent at Alang that the vessel is ready to be delivered physically to buyers. And 72Z, the last, all other terms and conditions to remain the same. My submission is that admittedly, no notice of readiness has been issued by the seller. It has not been received by the buyer. It is not even the case of either the appellant or Canara Bank that Canara Bank has issued any confirmation about the compliance with this requirement of additional condition introduced by way of the third amendment to the letter of credit. Now, which are the other terms and conditions which remain constant and unchanged through the entire process of an amendment? Kindly go to the original LC, which was issued on 26th of April. Your Honor may kindly see on the second page, condition number 42C. Am I with your Honor? 150 days from the date of physical delivery of the vessel. So the payment was to be made 150 days from the date of the physical delivery of the vessel. This condition has not changed, despite 3 amendments to the LC. The other, your Honor may kindly see 47A additional conditions on the third internal page. Your Honor will find 47A additional conditions. Kindly see condition number 8. The seller shall issue the notice of readiness for delivery only after the vessel has arrived at a safe anchorage along India and is ready for effecting physical delivery. So it is a condition of the letter of credit that the seller can issue the notice of readiness only after the vessel has arrived at Alang and is in a position and ready to be delivered. This is condition number 8. And the condition which was added by the third amendment, which I just showed, the third amendment of 24th May, that the document to be presented after the receipt of such an authenticated SWIFT message as under a tested telex or SWIFT advice from the opening bank confirming that the buyers have received the notice of readiness. Seller has not issued the notice of readiness in this matter. Seller was in no position to issue notice of readiness in this matter because the vessel did not depart from Indonesia. The vessel was under a court arrest, a fact which was suppressed from us and which we found out only later. Therefore, the first submission is that when in the last week of May, these documents were presented, and my friend is relying upon that 1st June letter, which they claim to be the document acceptance letter, and the 3rd June letter issued by Canara Bank. On the basis of that 1st June letter, that these documents have been accepted. On 19th of November, you are liable to pay as per the letter of credit. And having accepted the documents, now you cannot escape the liability by seeking an injunction. With respect, it is a very incomplete story. And Your Honor, in my humble submission, need to look into the development in the matter after the amendment to the memorandum of agreement and the letter of credit between May and November, when finally I was forced to file the suit. So I'll very quickly run through the relevant emails and correspondence to show to Your Honor what kind of a fraud is practiced upon the plaintiff and how the bank has a clear notice of such fraud. And the appellant before Your Honor, their conduct is also seriously questionable. So now kindly see what happened after those initial amendments to the memorandum of agreement and the amendment of LC. Now Your Honor may kindly see that after that 24th May 3rd amendment of the LC, Your Honor may have a look at the document at 3/12. The documents which are submitted by the appellant to Canara Bank. Your Honor will find 3/12 the various documents which the appellant, DBS, forwarded to Canara Bank, which includes a bill of sale, a notarial certificate, then a commercial invoice, some emails, letter of undertaking, seller certificate, and letter of undertaking deletion. These documents are submitted by the appellant, and on the strength of which they are claiming that this plaintiff cannot get an injunction because this is compliance with UCP, whatever is the current number. The first thing to notice in this presentation is that it does not include a notice of readiness. In the last week of May 2021, when the appellant attempted to present the documents to Canara Bank, those documents did not include a notice of readiness. And I take this opportunity to remind Your Honor of two important conditions of the LC. Condition number 8, that a seller can issue the notice of readiness only after the vessel has arrived at Alang and is in a position to be delivered or ready to be delivered. And that condition, which was initially part of document but brought to additional condition by way of amendment, that there has to be a confirmed message from Canara Bank that the buyer has received the notice of readiness. This exercise is admittedly not undertaken. Neither the seller has issued the notice of readiness, nor Canara Bank has confirmed that the buyer has acknowledged the receipt of the notice of readiness. In this context, please appreciate my letter of 1st June 2021 at item number 3/13. To the branch manager, Canara Bank, Bhavnagar, regarding accepting the documents of the vessel Seniha S. Dear sir, we are accepting the documents. The same will accept by us on arrival of ship along with present of notice of readiness. Kindly inform the DBS Bank, Singapore accordingly. We enclose herewith addendum number 3, as per which the delivery will be on or before 22nd of June 21. This letter is sought to be projected by the appellant as if it is an unconditional acceptance of the documents so as to entitle them to receive payment under the LC. My submission is that this is not stating what my friend wants Your Honor to read. This letter is very clear. English we have to understand it's a businessman writing and not a lawyer writing. So the articulation is not necessarily as good as perhaps a lawyer would write. But this businessman is writing a clear letter. We are accepting the documents. The same will accept by us on arrival of ship along with the present of notice of readiness. Kindly inform the DBS Bank accordingly. So whatever documents that you have sent, they are in order. But this will be accepted by us on arrival of the ship along with the present of notice of readiness. This second sentence of this 1st June letter not only shows the intention of the plaintiff, but it is in accord with those conditions of the letter of credit. I am not supposed to accept the documents presented by the DBS Bank or the appellant unless the presentation is in compliance with its own terms. The LC itself says that the documents have to be presented after the confirmed message is gone from Canara Bank to them that the buyer has received the notice of readiness. This has not happened. Now, this is the letter I wrote, and I have explained in the plaint in what circumstances this letter came to be written. That averment in my humble submission is required to be seen. Kindly see my plaint. That I have explained, sir. Paragraph number 11. Page nothing. No running page in my copy. And for running page I don't have, but paragraph 11. Thereafter, but I may be permitted to read from para 10 so that your honor gets the link of this 1st June letter. Once again, the letter of credit came to be amended for the 3rd time on 24th May 21. By virtue of the same, certain further changes were made in the terms of the letter of credit. Such changes are reflected in the delivery report issued by defendant number 2. It clearly provides that all other terms and conditions remain the same. Such change is consistent with the long settled customary practice prevailing at Alang, requiring payment to be made only upon the arrival of the vessel. There is no question of any advance payment to be made for the purpose of the ships brought to Alang shipyard. Defendant number 1 sent an email to Mr. Ashit Parikh, one of the brokers of defendant number 1, which was forwarded to the plaintiffs on 28 May 21. Such email stated that the list of documents submitted to defendant number 3 were attached. They were only some of the documents and not the entire documents required under the aforesaid letter of credit for presentation. Thereafter, Mr. Ashit Parikh approached the plaintiff number 2 and conveyed that the said vessel was about to sail and reach Alang on or before 22nd June 21, as promised by defendant number 1 and duly recorded in the 3rd addendum to the memorandum of agreement. He further conveyed that defendant number 1 needed a letter from the plaintiff to enable them to secure the early release of the said vessel. He also conveyed that such letter will not create any further liability for the plaintiffs and that the plaintiffs would be required to pay only as per the terms and conditions of the letter of credit. With his help and according to his instructions, the plaintiff addressed a letter to defendant number 2, the draft of which was actually dictated by Mr. Parikh on 1st June 21. In the said letter, it was stated as follows. Then I have reproduced the entire letter. Now what happens after 1st June? Sir, kindly see the letter 3rd June written by defendant number 2. Which page is? This is that. Sir, it is at 3/14. Your honor will find that this letter, whenever Canara Bank addresses to DBS Bank, it is in this format. And your honor will find the important part is in the narrative at point number 77. The documents for US dollars 31,58,540 under LC reference number so and so have been accepted to be paid on 19th of November 21. We will remit the negotiated amount as per your instructions on due date. If the payment falls on a Saturday or a non-banking, then on the next. Please avoid duplication. This is what Canara Bank wrote to the appellant on 3rd of June 2021. Your Honor will find the date in the first part under the heading delivery. Your Honor will find acknowledgement date. They write in the reverse sequence. 21 is the year, June, and 3rd. So 3rd June 21. So this is what Canara Bank writes on 3rd June 21 on the basis of my 1st June letter to Canara Bank. Now kindly see what happens further. There is a 4th amendment to the Memorandum of Agreement. On 22nd of June 21. Your Honor will find that with the main agreement at 3/3. June 21, Addendum 4. Due to COVID situation in Indonesia, vessel is being delayed. Following to read delivery date wherever mentioned in MOA, the vessel shall be delivered at Alang anchorage. Expected time of delivery 15th August 21 and date of cancellation 22nd August 21. This, Your Honor, may contrast with the earlier amendment, amendment number 3 on 21st of May 21. Expected time of delivery was 15th June and cancellation was 22nd June. So from 15 June to 15 August, 2 more months. They said that now, because of the COVID situation, there is a delay. Now it would be delivered on 15th August. While Your Honor is on this agreement, kindly see Addendum 5. This was effected on 18th of August 21. Following to read, again, due to COVID situation in Indonesia, vessel is being delayed. Following to read delivery date wherever mentioned in MOA, the vessel shall be delivered at Alang anchorage. Expected time of delivery 30th September, cancellation 6th October. So from 15th August to 30th September, another 6 weeks. This happens on 18th of August 21. Still the vessel does not come. Our patience is exhausted. Therefore, on 17th September 21, Addendum number 6, Your Honor may see reference to your email dated 17th September 21, request us to cancel the MOA and return back the LC. Accordingly, we hereby cancel the agreement dated 21st April 21 and Addendum number 5 showing the date of cancellation as 6th of October 21. Due to this cancellation, it is mutually agreed that either buyers and sellers have no claim against each other and seller is free to sell the vessel to any party. On 17th of September 21, the respondent number 1 and the seller, they cancel this agreement. Because Your Honor would have noticed that right from April 21, right up to September 21, there was no sign of the vessel on the horizon. Every time, due to one or the other reason, they kept on shifting the date of delivery of the vessel. So finally, both the parties agreed 17 September 21 that we'll cancel the agreement with no rights and claims against each other. And they said, we'll return your LC. The matter does not stop here. From 17th of September 21, right up to October 22nd or 24th, there is a plethora of communication between us and Canara Bank, and between Canara Bank and the appellant, DBS, in connection with this cancellation of the agreement. Therefore, the appellant had a notice of cancellation of this agreement from the beginning, and kindly see their conduct. Now I will show to your honor only the relevant correspondence after 17 September 21. Because the earlier correspondence I have shown up to 1st June, 3rd June, Canara Bank's letter to them, my letter to Canara Bank with a very imperfect English. The point is that between June to 17 September, the correspondence was ultimately, when are you delivering the vessel? The gist of the correspondence. They kept on giving the reasons. 17 September, they said, okay, we cancel. No claims against each other. LC to be cancelled. Now kindly see what happens after 17 September 21. And what is the conduct and the role of the appellant before your honor. So now, after 17 September, the first thing to notice is the document at mark 3/44 of the same date, 17th of September. The buyer writing to, the seller writing to the buyer, to us, 3/44. Your honor will find it is from Gandhi email. Am I with your honor at 3/44? Running page. Sir, this is an email of 17th September 21 at 4:27 p.m.
Tuesday, 4th May 2021, 10:35.
No, sir, not May 21. I request your honor to look at 17th September email at 3/44. Can I assist if your honor can? Yes, sir.
17th September.
Yes, sir. The date is somewhere in the 4th line of that document. It doesn't appear at the top. It is from Gandhi at capitalcorpasia.com to D. Hussain Sheth at yahoo.co.in.
I think Canara Bank needs it. Yes.
No, no, sir, no, sir.
From
It's a
Ashit
CC to
Parikh-
Canara Bank.
From Ashit Parikh to Canara Bank. This is 3/44.
No, sir, I want your honor to look at the email sent by Mr. Apurva Gandhi.
15 September.
17th September.
17 September, yes. Gandhi,
Yes, sir.
capitalcorp.com.
Yes, sir. That letter I want your honor to look at.
Yes.
Dear all, as per the discussion we had and addendum number 6 we signed. Am I with your honor?
Yes.
As per the discussion we had and addendum number 6 we signed for the MOA dated 21st April 21, we respect your request to do the cancellation of the above mentioned MOA, and please do advise how you would like to proceed to conclude the process of cancellation of LC. So on 17th of September, immediately after the agreement was cancelled, this is the email which was sent to the plaintiff. That please advise how you would like to conclude the process of cancellation of LC. Now, after this 17th September, kindly go to my email to defendant number 1.
Yes.
Where is my mail? Plaintiff's email to D1. Yes. Would your honor kindly see the next page? From Dilawar Hussain, date 17th September 21. Kindly see the time 17:07. To Mr. Apurva Gandhi, Azman, who is Capital Corpsman, CC to Canara Bank, etc. We are in receipt of your mail regarding the memorandum of agreement of cancellation of LC between us as per addendum number 6 signed by us. We would like to confirm you for cancellation from our side, since we are not in receipt of physical delivery of vessel. And we would like to inform you that we would be returning you the original documents as per our contract. Kindly acknowledge our mail and help us with a reply mail for intimation of cancellation of LC, so that we may ask our bank to proceed for cancellation of LC. So on the same day, 17th September, when that addendum number 6 is signed, with both parties saying that we have no claim against each other, it was also agreed. They said, please advise how you would like to proceed for cancellation of LC. We responded, since we have not received the delivery of the vessel, we would like to cancel the LC. Now, after that, this email was acknowledged by the buyer, which is at the top. Then kindly see 18th September 21. This is an important email. This is written by Canara Bank to the appellant. Your honor will find it not anywhere near 3/44, but it is at item number 3/20. This is 18th of September 21. Yes. Your Honor will find the date in the first table under the heading delivery 21/09/18. This is 18th of September 21. The narrative is in the last column at 77 capital A. This is what Canara Bank wrote to the appellant. As per the mutual agreement between applicant and beneficiary, applicant has informed us to cancel the MT 700 reference number so and so, dated so and so, 21st April 26, and subsequent reference number so and so, all the amendments. In the light of above, we request your good bank to consider the same and treat the above mentioned MT number so and so as null and void. Kindly update the same in your records and confirm us the same through authenticated SWIFT message. So your Honor may appreciate that on 17th September this agreement was cancelled. On 18th September, at the earliest possible opportunity, Canara Bank wrote to appellant that this is the development in the matter. This LC needs to be cancelled, treated as null and void. 18th September. Kindly see now another letter of 21st September 2021. It is at item number 3/21. Sir, this is written by the seller, the Indonesian seller to the appellant, his own bank. Your Honor will find the date 21st of September 21. To DBS Bank Singapore, reference number, proceeding for cancellation of the letter of credit dated so and so. Dear sir, madam, reference to your message advising us accept of SWIFT message from Canara Opening Bank, Mumbai, confirming cancellation of letter of credit number so and so. In this regard, buyer has now cancelled the MOA and copy of the addendum number 6 is enclosed herewith. Request to kindly cancel the said letter of credit and advise the opening bank at the earliest. So not only Canara Bank is writing to the appellant, but the seller is also writing to the appellant that yes, we have agreed to cancel the agreement. The addendum 6 is for cancellation of the agreement, and it is agreed that the LC may be cancelled. So on 21st September 21, now appellant receives a second communication. The first communication is 18th September from Canara Bank. 21st September is a communication from their own beneficiary, the seller, that yes, this is cancelled and LC has to be cancelled, and accordingly you may confirm. This is 21st of September 21. Now kindly see on 21st September 21,